What time you got?
Okay.
Okay. This is the regular scheduled meeting of the Board of Architectural and Engineering Examiners. Is taking place in Conference Room 1B of the Davy Crockett Tower of 500 James Robinson Parkway, Nashville, Tennessee. And notice of this board meeting was posted on the board's website on November 25th, 2013. So I call this meeting to order. Roll call.
Susan Ballard,
Here.
Hal Balthrop, Wilson Borden,
Here.
Robert Campbell,
Present.
Jerome Headley,
Present.
Philip Lim,
Yeah.
Bill Lockwood,
Here.
Rick Thompson,
Here.
Frank Waxter,
Here.
Ricky Bursai,
Here.
Laura Reinbold, Stephen King. You have a quorum.
Thank you. Acknowledged guest. If you'd maybe rise and just introduce yourselves, then we'll.
I'm Mark Hawes, architect from Jackson, Tennessee.
Huh?
Don Baltimore, representing the Tennessee Interior Design Coalition.
Yeah, who's that stranger back?
Like always, I'm not paying attention.
No,
I'm Alton, head
okay.
coach,
Thank you.
former associate board member.
Okay. Is there any announcements? Seeing none. Review agenda for changes and/or additions? No comments. Presentation of resolution to Alton Heathcote. I have the honor of presenting to Alton, and I'll come out here.
Well, I'll come up here in the middle.
And I will read this.
Go ahead. I can imagine what somebody else might say.
Yeah, right. This is the State of Tennessee State Board of Architecture and Engineering. Gratitude for the service of Alton Heathcote. Qualities both his professional and personal life, and whereas he may respectful toward others, even though of differing views.
One more tap.
I wrote most of that.
That's why he's not here. He does
Oh, you have to stand for a.
Oh, for a picture. Okay. Oh, I turned
Yeah,
around.
yeah.
Turn it around. It's like Darth Vader.
It's not me.
I thought a selfie. No, what's it? It's, what is it, what's it called when you get in a photograph?
Oh, photo bomb.
Photo bomb. That's me. Bomber. I sit behind him and go, I'm your father. Do as I say.
Thanks to everybody.
Thank you.
Well, I missed most of y'all. But I do miss all the staff a whole lot. Thank you very much for this. I treasure this. This was valuable.
Well, now, Alton, you don't have to be a stranger. You can come sit in the audience.
I'm afraid I'm not confident to do that. I'm glad that you got a much more competent and much better looking replacement. And Laura, congratulations. This is a terrific group. I know we talked before about it. I thank all of y'all. This is wonderful. I appreciate it.
Thank you very much. Okay, we're going on to the consent agenda. It'll be page 7 in your electronic version. Do I have review the minutes of October 2013 board meeting? Is there any,
Move they be approved as submitted.
do I have a second?
Second.
All in favor, say aye.
Aye.
Any opposed? Passed. Staff complaint reports. It's page 15 in your electronic book.
These are all complaints where the respondent was disciplined in another jurisdiction. The discipline was less than a suspension or revocation, and we issued a letter of caution in accordance with board policy and recommend closure.
Mr. Chairman.
Do I have a second?
Second.
All in favor, say aye.
Aye.
Any opposed? Passes. Financial administrative update.
That's me, isn't it?
Yep.
Wait a minute. Oh, it's not me then.
He's not here yet, so we may have to move to the next item, I would say.
He's up on the 6th floor.
No, I told him it was
No,
on this
okay,
floor,
good.
so, yeah.
That'd be in everybody's best interest.
We'll go on to the professional society reports. Don,
Did I use the microphone over there on the table?
Over here?
Yeah, that way Susan will be able to hear.
Okay.
Yeah.
It's on, right?
Yeah.
Good morning. My name is Ashley Cates. I am the new Executive Vice President of AIA Tennessee. Not replacing Connie Wallace, I'm just the new one. Connie, we're still in transition, so Connie's still in the office technically, helping me out, educating me on the background of architects and engineers, as well as Candy Toller and Nathan Ridley. I've met with him, LaDon, and others. So we have a good support system for AIA Tennessee as a new director. So look forward to working with each of you. I'm sorry I wasn't able to make it at the past meeting. I had a prior commitment, but I plan on being at all the others that you have. So I wanted to say thank you for catching the new procurement on the Tennessee Code 124107. I had actually looked that up, and I had a member ask me about 106, and I looked up 106, and I said, this doesn't really have anything to do with what you're requesting. And we just chalked it up to LexisNexis being wrong. So thank you for that catch. We did some digging, and we've learned that was part of the procurement procedure sponsored by the administration, and it was a 125-page bill. So that's probably why, at least I think the architects and engineers in the industry didn't really catch it. So also, Connie and I, we did a little bit of digging, and I've read the report. My members, or the state attorney general opinion, my members say it's important in procurement. Connie actually says this holds up, so I can pass this out to you all. But we didn't find it because it was actually under construction management, and when you do searches, it doesn't come up under engineers or architects. So to give that, I don't know who I need to give it to if they want to pass that out, just for your reference. We had a great planning retreat. The AIA board We met in November. So we have some committees we're going to be forming. If you all, if our members on the board would like to participate, we have a government relations committee, communications committee, and a membership committee forming. So welcome you all to participate in any way on that. I'm sorry, somebody have a question? Oh. Also, I wanted to let you know that yesterday, Don Miller, our incoming president, and Scott Busby, our outgoing president, current president still, we met with the Secretary of State, Trey Hargett, and his Chief of Staff, Jonathan Rummel. We had a good meeting. We're looking forward to working with Peter Heimbach, that's going to be our new state architect. So we're excited about the new era of, I guess, AIA Tennessee and the new executive vice president we have, and I look forward to working with Peter. So if you all have any concerns or suggestions, please feel free to contact me. Love talking to each of you and getting to know you. We're also still working, participating in the QIC task force. The state architect, we're still going to have those. Alan Robertson led those once Commissioner Oglesby moved into his new position. And our next meeting, the next meeting is going to be next Wednesday. So we're still participating in that and hoping to inform our members of anything moving forward. We also actually, the 4 industries, sent out a memorandum for Design Build One policy, just straight. It doesn't have anything to do affecting the public and safety, welfare. And so we've sent that to the state architect for his approval and memorandum. And I'm happy to provide that to you all if you need me to. I can send it to Jonathan. Also, let's see, we have our convention dates. They're pretty much set. So it's July 30th through August 1st in Nashville again, Music City Center. You'll receive information about that. And our Day on the Hill is set for Wednesday, March the 5th. I've got to get the outline together, and once I do that, I can send information out and provide that to you all. So be on the lookout for information coming from us on that. So just to give a quick background before I wrap up, I have my background includes I worked for the Tennessee Medical Association for 2 years prior to this position as the marketing director. And prior to the Tennessee Medical Association, I was with the Tennessee Cable Telecommunications Association. So a lot of my time was spent over in the other building, TRA. But I'm excited about it. My background is in government relations. Been on the Hill, and I've been in Nashville since 2003. I worked in Knoxville after graduating the University of Tennessee in 2001. And I am a native of Giles County. You just never know. There's small town ties run deep sometimes. So I look forward to working with each of you, and please don't hesitate to contact me if you have any questions or need me for anything. Thanks.
Thank you very much.
Good morning. I'm Don Falterbourg, representing the Tennessee Interior Design Coalition, and I'm glad to see all the Christmas ties on this morning. Drag them out of the closet and wear them. I don't have a lot to report. We've had a statewide meeting for the American Society of Interior Designers Tennessee chapter, which was successful and well attended. Several continuing education units were offered, especially on health, safety, and welfare. As far as legislation next year, we are not planning on introducing anything. We'll just monitor all of the legislation that's now presented and plus has already been introduced, and hopefully work together with the board and the other associations. And I too want to thank John for catching that construction law that got moved over to another section. Thank you.
Thank you, Don. I guess that's all the society reports. I guess we're going to go back to the financial report. Commissioner?
Good morning.
Good morning.
Chairman, commissioners, how are you all?
Good.
Sorry it's so hot.
Better down here than it was
Yes,
upstairs.
it's much better. I think I may relocate for the day. It is burning up upstairs. Do you all have a copy of the report? I've got one. I brought one just in case you did not. Okay. I'm going to try to make this as short and sweet as possible. for you. This is a 4-year look at your board's operation. We're going to start coming before you annually after we get year end closed and update you each year so you know where you are. We think it's important that you all have a grasp on where your money is coming from and where it's going and what we're doing with it, give you an opportunity to ask any questions that you need to ask. And so I'm going to proceed at any point. If I'm not going to go through every line item, but at any point, if you guys want to stop and ask a question, feel free to do that. So if you'll notice in the far right column, you've got your expenditures by object for fiscal year 12-13, which is the year that just ended. Your regular salary and wages were $243,149. Total was $365,012. That was very much in line with the previous 3 years. That also includes a 1.5% raise that went into effect July 1. So then I'll drop down to the grand total on your other expenditures, which is $1,055,694. Again, right in line with the previous 3 years. That's due to the rock solid management that you have in your program area. They do a great job. So they've been able, in spite of the fact that everything else has gone up, they've been able to toe the line on your expenses. So then if you come down and look at total expenditures, it's $1,291,691. That is down from the previous 3 years. So again, hats off to Director Cothran and his staff for keeping your expenses low, in spite of the fact that they did have a 1.5% raise across the board to the staff members. So very, very proud of that. Your licensing revenue was $1,560,771. Again, you guys are just as, you can set your watch by you with that, with your revenue. We're also now pulling out your case and complaint revenue, which is something that had not been done previously, so you can see actually the results of your disciplinary actions that you've taken. That was $15,400, and your net revenue was $1,474,671, leaving your fiscal year balance at $182,979, which is higher than any of the previous 3 years. And that left your balance for your reserve fund at $1,191,575. Thank you. Questions?
Question.
Sure.
How just observation. How come the state regulatory fee has gone up from 75,000 to 101,000? Is there a reason for that?
That is a fee that is based on the number of your licenses, and they will sometimes, you'll move things, they will move things between the lines. If you'll notice back in state professional services back in fiscal year 9 and 10 was 140,000. So they reclass how they do things. I typically bring my accountant to these things with me because she has a much better knowledge of the specific line items with that. She was actually unavailable this morning. So, but that is the state regulatory fee is the fee that is charged per license for the transaction.
Thank you, sir.
And your license, I've actually got your license totals here with me. And this is the reason is you had 15,260 licenses in 2013. In 2010, you had 14,582. 2011, 14,725. 2012, 15,165. So you seem to be adding about between 200 and 500 licensees each year. So that's good. That's about all I got on the budget. You guys have any questions?
Thank you.
I got one quick comment, Mr. Chairman, if you don't mind, and you're probably aware of this, but we have gone to computer-based testing for the first phase of our engineering testing. And we are mildly, not overly concerned, but mildly concerned because the fees have increased and we are going to see a decrease. We believe college taking that test, and y'all have probably had this conversation, but that may put a little bit of downward pressure on some of our revenue side. It may equal out, but if we have less kids taking that exam,
Right.
And this, over time, we may have less people applying for licensure because that number may decrease. We're gonna try to monitor that and see what happens. Is that a fair, I mean, there's some possibilities there that we're not real happy about, but where our hands are kind of tied by a national organization that we're continuing to fight. So I just wanted you to be, as we're concerned about that on the engineering side.
And we're aware of that. And Director Cawthorn and I have talked about that in the past, and we know that that is coming, and it's something that we need to keep on our radar and watch. I think the way that we distribute your administrative costs that you receive from the Commissioner's office and the consumption that your program, the division-wide consumer, the fees that you're charged there are directly related to the number of licenses that you use, and it is about as fair a system as you could possibly have. And we feel like with that and with some, conscious reviewing, that we'll be okay. We're not concerned. You guys have not had a problem with paying your bills. And we do, of course, with the sunset, you have 2 years. If we were to run in the red from a operating standpoint for one fiscal year, it would not be fatal. And it would give us an opportunity to react and to make the changes that we would need to make sure that we kept you in the black, got you back.
Thank you. Any other questions? Thank you very much.
Thank you all so much again. I apologize for the heat, and they took our chillers out thinking that, well, surely it's not going to be 70 degrees in December. They took the chillers out to replace them, and of course we get 70 degrees in December. So.
Is that
You'll be
Murphy's
all right by the
HVAC?
Sir?
Was that Murphy's HVAC?
I don't know. Thank you all.
Thank you. We're now at the legal case reports.
Everybody have a handout? What?
Oh, you already handed him out, didn't you?
It's not nearly as bad as it looks because some of these are represented, and there's a few of them that board members reviewed that need some discussion. So I'm just going to run through the easy ones first. Under the heading New Case is case number 2013-020331. This complaint alleges the respondent engineer failed to disclose a felony conviction in 1995 upon applying for license, and he applied under the NCAAS model law standards, so he got his license that way. Without disclosing the felony, which may constitute deceit in obtaining a license and be subject to discipline pursuant to our statute. The respondent claims in a written reply that the omission was unintentional, of course, and accepts that reporting the matter was his responsibility. The application file has since been updated. The respondent's registered in several states, and his Tennessee license expires on March 31st of 2015. We don't have any complaint history for this particular respondent. Recommendation is to close the case with a letter of warning, and Mr. Lim, I didn't say law and rule exam because it didn't implicate professional competency, but if you want to add that, we certainly can. Do you want to go through these, or do you want to take them one at a time? It doesn't matter to me.
Let's go each, let's take this one. Go ahead.
Mr. Chairman, I think in keeping with the consistency, anytime when somebody is not clear with our law and rules, I think it's for the board to request them to take and pass the law and rule exam. Just as a way that we spend time writing law and rules, I think a register needs to be paid attention to the law and rules. So I recommend to add that we will accept our attorney recommendation in addition to that, ask the applicant to take and pass the law and rule exam.
So if it's an informal discipline like a letter, we can request it. If it's formal discipline, like assessing a civil penalty, we can require them to take it. So I sort of left that sort of open if you wanted to move up from a letter of warning to something else. I was going to leave it. I don't know how serious you consider this disclosure, non-disclosure of a felony that happened long ago, but our model law and rules, or the NCAAS model law standard, gave him a license, no questions asked. So
could we request him to take it? So we could make
Yeah.
this and just request it.
Yeah, and he
So you want to,
may not be aware it's a request. He may think he has to.
Well, I mean, just a question to me, why do you believe that he's not? Well, just basically in the letter says that we give you a letter warning, the board has requested you take and pass the law review exam. And so in my mind, when I read the kind of letter, I'll probably take it, so I wouldn't fuss at me.
Oh, there's
Doesn't mean
probably
that
no
somebody
doubt.
didn't catch, I understand where you're coming from, the NCWS people gave him the license, but it is our board to do due diligence, and when we catch something, we have to be the one to come out front and not say, oh, never mind, because the previous guy didn't catch him. So we just need to ignore it. So I think the fact that it's come to light to us, I think we need to do something about it.
I don't really remember how we've treated this before, or if we've even had a case like this before. So I was a little unclear on what our precedent was. Have we had a non-disclosure like this before?
All since I've been with the board.
So I'm not sure how the seriously the board feels about this. Kind of leaving it open, Mr. Thompson.
His license is scheduled to be renewed for the 31st of 2015. If he doesn't take the letter seriously, and even though it's a request to take and pass the laws and rules exam, where there may be some question as to whether he gets a renewal again.
I considered a nominal civil penalty, like $250, formal discipline, to express our displeasure. I didn't know if you all would go along with that or not. Because there's no, we know he did it. It's not one of those where we have just probable cause. We know he did it.
Do we need a motion for that?
Yes, if you
I've
want
got
to
a
Right now,
motion,
he's got a
but
motion out.
I can withdraw my motion. Let me withdraw it, yeah.
okay.
Philip, you want to amend your motion with the penalty and,
Yep, okay.
since it was your motion?
Yeah. Well, so I'm amend my motion to that we send a $250 penalty.
I don't like low penalties. 500 would be more my preference, but see, I was thinking of doing a lot of things, but I just sort of left it up to y'all to discuss because I didn't know how. Felony non-disclosures, I think, is something you should not do. Applying for, because if you don't disclose it, it seems like you know that you should.
Got a motion, but we don't have a second.
No, but I think there's a
A good question before the motion.
Well, I'll second it so we can have discussion.
Okay,
That's
yes.
fine. How long ago was the felony?
95 is a conviction.
I'm sorry, I should read that. So this application would make that almost 20 years, 18 years.
I don't know how we called it.
I think he had applied in another state, and they had denied his application because he did not disclose a felony on his application to them. And it was reported through the National Disciplinary Database is how we became aware of it. So I think he applied in Tennessee. It's I think late 90s is when he obtained his license here. He's been registered the whole time, but we just recently found out through the other jurisdiction
That changed.
of the felony.
So there was only probably a possibility of a 5-year lapse between his felony conviction and his application.
I think so. Yeah.
Okay, so that would change my opinion.
I don't have the file with me, but yeah.
Okay. That's something you should remember. Sometimes things that happened almost 20 years ago are.
Wilson?
I just want to understand, I don't know what the applications ask for, the information it asks for when you apply for your license. Does it ask if you've ever had any
Yeah, in black and
criminal
white.
activity or something? Okay.
There's a big box that says yes or no.
Okay.
Yeah.
He marked no.
We've got a motion and a second. Any other discussion?
I don't really mind telling you the conviction was possession of a controlled substance and simple assault. just so you know, it wasn't, battery or rape or something like that. It was still a felony.
This is Susan. I think we need to raise the penalty to $500. I think other people that have done other things, that's been our minimum penalty. I think we need to be consistent.
You asking me for a friendly amendment? Susan?
Yes, I am.
Okay, I'll do the friendly amendment that we civil penalty of $500.
On rule exam.
Yeah, taking past law and rule exam. Mr. Kimball, would you
I
want?
will accept that on the second. Yes, sir.
Okay, so we can.
I have a motion and a second. Any other further discussion? All in favor, say aye.
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 Any opposed? Motion carries.
I feel like I should have gone with my first instinct on that one. All right, next heading, cases with updated information. There's a few of them. They're very similar. Except, so number 2 is 2013-001-1971. This was presented to you in February of this year, and this was a privilege tax case. And in italics, you can see that's what was on your report at that time. And of course, based on that, you authorized a formal hearing. Well, since that time, it was referred to litigation in March of this year. The respondent's license expired at the end of March of this year. There's been no attempt to renew, at the end of August, I'm sorry. No attempt to renew since August 31st. So recommend close the case. The matter will be addressed if any renewal or reapplication is attempted.
Move that we accept the recommendation of council.
Have a second.
Second.
Any further discussion? All in favor, say aye.
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 Opposed? Motion carries.
Right, number 3, 2013-002-011. And this matter was presented in February of this year. Same thing. And you approved a formal hearing. And it was sent to litigation on March 28th because we didn't hear anything from them. This respondent entered into bankruptcy protection in May of this year and has a license active through August 31st, 2014. Now, the recommendation is to close the case. The board will not allow license renewal or reapplication until the delinquency matter is resolved after the bankruptcy is settled. Litigation counsel tells me that while he's under bankruptcy protection, we can't do anything. Because I thought, well, he's still got a license and it's still active and he can still work. And the object is to suspend him because he was delinquent. So I didn't want to close the case and then just allow him to keep practicing. But as it turns out, under federal law, we can't touch him anyway. So after he comes out of bankruptcy, then we can deal with it if he reapplies. Because by the time he's out of bankruptcy, he expires August of next year. I doubt if he'll be out by then. So the recommendation is to close the case.
Do I have a motion?
So moved.
Second.
Second.
I have a motion. Any further discussion?
Just for clarity, John, how the staff know that his reapplication? You put a flag in the file.
Yeah, we can put a flag on his file, yeah, a note on that. Now, as far as knowing when he comes out of bankruptcy protection, I don't know exactly how we'll determine that.
I expect that he'll be in bankruptcy beyond August of 2014. His license will expire by then, and he'll have to come back and reapply, and that's how we'll know.
So, is he protected? Do we have to renew his license, or do we have the authority to not renew his license?
We have the authority to not renew it unless he deals with this delinquency he's got. Whenever he does come back wanting his license back is when we're going to deal with it.
I have a motion and a second. Any further discussion? All in favor, say aye.
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 Opposed? None there, so that motion carries.
Or 2013-002031. This was another February case you were presented with. Privilege tax case, same thing. You authorized a formal hearing that went to litigation in March. And since that time, this person's license expired July 31st of this year, and there has been no word since. So recommend close the case. The matter will be addressed if any renewal or reapplication is attempted. How long is the renewal period?
6 months.
Okay. After 6 months from July 31st, they're going to have to reapply.
Have a motion.
So moved.
Do I have a second?
Second.
I have a motion and a second. Any further discussion?
Same thing, likewise, will be a flag, the staff will put a flag on this file too, right?
All in favor, say aye.
Aye.
Opposed? Motion carries.
Number 5 is 2013-002121. Again, privilege tax matter presented in February. You authorized a formal hearing, the consent order to voluntarily suspend, which she didn't take, so it went to litigation. Since then, their license expired on September 30th of this year. No attempt at renewal. Recommend the same thing. Close the case. We'll address it when they try to get their license back.
Do I have a motion?
So moved.
Do I have a second?
Second.
Thank you. Any further discussion? All in favor, say aye.
Aye.
Opposed?
Are we gonna
Motion-
flag the folder?
Same thing.
Right,
Yep.
same thing.
Okay.
Motion carried.
Right, number 6 is 2013-009551. This one was presented to you in June of this year. Another privilege tax case. You authorized a formal hearing. We didn't hear from them. Sent it to litigation in August of this year. This person has notified the board offices that he surrenders his license and he is no longer a board registrant. Once again, close the case and the matter will be addressed if any reapplication is attempted.
Do I have a motion?
So moved.
Do I have a second?
Second.
Any further discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
All right, this one is a little different. Number 7 is 2010-033101. This was presented to you on April 14th of 2011. And then here's the italics about what this person did. And it's too bad Elton's not here anymore because he actually reviewed this case. Basically, I mean, I can let you read this, but the long and the short of it is this person was involved in compaction data. Some of you may remember this. This is the guy that was doing compaction data for HUD to see if sites were suitable to put mobile homes on. As it turns out, he wasn't doing it correctly. He was actually either not doing it or not doing it the way he should, and this was many, many times he did it. So, Mr. Heathcote, we had an informal conference with him, teleconference. The guy knows he shouldn't have done what he did. We brought that back to the board, and then there's some capitals here. The board discussion synopsis was as follows, and this pretty much says how the board talked about it. And after talking about it, they figured out or decided that it fell under gross negligence and assessed a humongous civil penalty. Voluntary revocation, $10,000 civil penalty. Of course, they didn't take that. The matter was referred to litigation on July 8th of 2011, where it sat there. Since then, the respondent's license has expired as of April 30th, 2012. This person has retired and is no longer using their license. The new litigation counsel and I talked about this. There was a recommendation to close the case, and the matter will be addressed if any reapplication is attempted, which I don't really agree with because he's retired and he's not coming back. So there's an or. Proceed with a formal hearing with the intention of revoking any rights to renew and prohibiting any reapplication.
I remember this case. I mean, there were, I think it's 150 is what we said, but I think there may actually have been more, and it happened over a several-year period.
Over 100.
Yeah, and my opinion is, for those that didn't know about it, he was supposedly inspecting sites, doing a foundation inspection for mobile homes, modular homes, and some of those had problems. That's the reason that he was reported. This, to me, I mean, we as engineers are representing when we go do these things that we've done work on it. To me, this is a gross violation of our duty to protect the health, safety, and welfare of the public. I would be much in favor of proceeding on with a hearing, with assessing.
That's what I wanted.
You know, I think I don't know exactly what we argued. $10,000 still seems to be a little low to me,
It
but
was
that's
low,
okay.
but we wanted to arrive at something we might possibly
right.
get.
So, but I believe that this is a case where we've got somebody in our profession that is violating that trust that's been placed in them. I don't care if they're retired. I really don't care if they would be deceased. I think this is something that goes above what we need to, and we need to go ahead and make sure this gets prosecuted, because it's it's one thing. The people that he took advantage of too, and I'm making a general statement, were probably less sophisticated in knowing that they were taken advantage of, and that to me is even a more of a modifying reason.
My opinion, and that's why I put the big OR in there. I agree with you. I think that if you've done it, you've done it. And it doesn't matter if you're practicing anymore. And I thought about the potential of future damage, because we don't know what's going to happen at those sites that this person analyzed. There's a potential for injury in the future because of what he did. Mr.
Wilson?
I move that we proceed with a formal hearing with the intention of revoking any rights to renew and prohibiting any reapplication.
I'll second that.
Thank you. I have a motion and a second. Any,
Second.
I thought the civil penalty was part of it. It's not the 10,000.
No, I forgot to put it in there, but I think it needs to be in there.
That's fine.
Yeah, and I'll amend my second to add the $10,000 penalty.
You could just say we're going to uphold the previous decision, which included all that. Let's just move ahead with what you're doing, because it's active right now.
how's the motion need to read?
Proceed with the formal hearing with the intention of revoking any rights to renew and prohibiting any reapplication and the assessment of a $10,000 civil penalty.
Wilson's,
That's fine.
Yes, I agree with the way that was stated. Yes, sir.
okay. Any further discussion? All in favor, say aye.
Aye.
Opposed? Motion carries.
All right, now we're in the territory of cases that are under board member review. The first one is listed as number 8, 2013-018361. This complaint alleges a respondent, a licensed architect, committed misconduct through the improper use of his seal while providing professional architectural services and potential violation of our authorities. A written reply from the respondent attempts to explain the respondent's role in the production of the construction documents that are the subject of this matter. These complaint materials were forwarded to Architect Board member Mr. Wagster for review to determine if any probable cause exists for possible discipline.
You did get the letter I sent you like yesterday or day before that I finally did review that. Basically the code officials sent copies of drawings of the seals that this person used. On the drawings appeared to be prepared by an engineer, and then this was an architect working with him. They both had the seals on some of the drawings. But anyway, one of the set of drawings sent, the seals appear to be cut off of a piece of paper and taped to the drawings and printed. And this includes the seal, the signature, and the date, which is in violation of our rules. And then the other was a set of drawings in which he claimed he was using a digital signature. But I think he doesn't that's his seal. He has a digitized version of his signature. Those are applied on some drawings. And, that's not a verifiable digital signature. That's just a copy of a signature he made for a drawing. Writes a letter and responding to the claim, and his letter responds. Well, one portion of it responds to this. The rest of it was kind of saying he was in responsible charge of the drawings. Now, why he answered that leaves question to me. Is we weren't asking was he in responsible charge. So it just leaves questions in my mind. I don't think I can answer them with the evidence that I have. Be researched further or investigated further, but I don't know if we spend the time and the money to do it. And so my recommendation was to, and from what I just heard, I don't know if I can do this, but it was a letter of warning and for him to take the laws and rules exam.
Make them do it, but we've done
I'd
it
like to
before
make
and they
this
have
guy,
complied. So,
he misunderstands and then writes a letter pretty much letting me know he really misunderstands. So, as far as raising it to a fine, maybe we need to do that.
Do you believe, based on what you've seen, that his actions are, you say he didn't understand, would that lead him not to understand other things that on some level are a whole lot more important, like how Part A goes into Part B?
The drawings that I saw, I didn't see anything particularly wrong with them. There's a question in my mind is who prepared them. And I did talk with a code official, and one of the reasons I have suspicions of that is he said he called this person and said he had some questions on the plans, and it said he didn't know what he was talking about. And then later called back and said, yeah, now I remember I did do those.
something rotten in Denmark.
Yeah, but there's nothing sitting in front of me that I had that I could
That's
hang on
what
to.
letters of warning are. We suspect something's not right. We just don't have the solid proof.
Jerome?
You said that it appeared that the seal and signature were, say, cut out from another drawing and then taped on and reproduced, and you could see outlines?
Yeah, you can see the shadows of where the piece of paper was put down and the shadow of the piece of tape.
He knows what he's doing. He apparently he knows what he's doing.
I'm not sure he knew he did that. Yeah.
I know one thing. I don't take a pair of scissors and cut out the seal with signature on it and then tape it on a drawing and send it to and submit it, get it reproduced and submit it to a building official for plan approval. That's, he knows what he's doing.
Another aspect of this is that, the drawings that were sealed, there's probably 10 drawings. And, if I've got a set of drawings that's got 150 seals I've got to sign, I might want to have a digital signature, but if you've only got to sign your signature 10 times, why do you have to go through all this process in the first place?
Ask Frank. I mean, it looks like he violated the seal rule. So
Right.
you could assess him a penalty. And I'm wondering why a letter of warning and not a penalty. Is it because you suspect that he's done, maybe there have been other rules broken, such as stamping something that he didn't?
That's a suspicion, but I don't.
Well, there's no
think so.
complaint history for this person.
Right.
I don't know how long they've had a license. Speculation as to why somebody would do something like that.
I consider, unless we investigate further, we might consider a penalty instead of a warning. And
Can you do both a letter of warning and a penalty and the law and rules?
The cover letter would become the letter of warning. So could make it a letter of reprimand, which we've done before.
I would like to make a motion then. I think, I mean, this to me seems, it's wrong. And whether he was doing something expedient or he was doing something to purposefully get around something, both cases are wrong. I would recommend a letter of warning with a $1,000 penalty. I think that's in line with our, because there were 10 sheets you said. $1,000 penalty and take the laws and rules take and pass the laws and rules examination.
Seem clumsy or sinister? I mean,
Motion, do I have a second?
Second.
All right, so I have a second. Further discussion.
wondering, it didn't sound, I've seen the drawings, and I don't see, there didn't look like there's any attempt to conceal what he was doing. It was obvious that something was not right.
Other than his letter, yeah, I agree.
Pretty foolish to try to do something like that.
My question is that if he just doesn't understand a digital seal and how you apply that, does that equate to that type of fine?
That's what I was saying. If he's been around a while and doesn't understand what digital seals are and too stubborn to ask what they are, that's one thing. I mean, I couldn't see where any authority having jurisdiction would be fooled by those drawings, thinking that they were legitimate, stamped and signed like they're supposed to be.
Well, was a building official who reported or filed the complaint?
Yeah.
Okay.
One thing, Bob, I said 10, that was an offhand number. We might just say $100 a sheet.
Already got him. Close enough. Yeah. We have a motion and a second. Any further discussion? Seeing none, call for the, all in favor say aye.
Aye.
Opposed? Seeing none, that motion carries.
$1,000 civil penalty, law and rule exam. Alrighty, number 9, 10, 11. This is all the same matter. 2013-02248-1, 2013-02249-1, 2013-02251. And these complaints allege the respondents, who are all licensed architects, committed misconduct in their professional practice by improperly submitting proposals for contracts to provide services for the same publicly funded project, in potential violation of our rules. And these materials were given to Mr. Headley for review to see if there's anything that suggests probable cause for discipline.
What this involves is that a county agency had submitted published a request for proposals, and in it, it was for a judicial building and I believe jail. And they their facilities were getting outdated, and they needed to plan this out and I guess update and maybe plan for the future. Well, the three complainants did submit proposals, responded to it, but in reviewing the documentation, John had sent this agency a letter about requesting a fee as part of the proposal. And the agency responded back, and they had said in so many words that this was not, they were not asking for a fee proposal. They were trying to get numbers to use for budgetary purposes. Well, one of the complainants, and they did, the county also, this agency sent out an addendum and stated in there that the respondents, when they submit their package, they do not need, I'm taking it as their option as do not need to include a fee. But the fee would not be, if they did provide one in there, it was for, they were trying to clarify it and in what they're doing. So the three respondents did submit proposals. Two of them had their fees, and you could see it. The third one had submitted, put their fee in a separate envelope and said if they are selected, if they're the selected firm, that they would, that's when this thing would be open. And subsequently, the one firm that put theirs in an envelope, they were chosen. But during the negotiations, it turns out that the agency adopted a policy that whoever did the study would not be eligible to actually do the respond to providing the A&E design services. So that firm withdrew. Their sealed envelope was never opened. The agency responded back about this and acknowledged that. So, and responded in that particular respondent also submitted in their response back that others that had submitted their RFQs withdrew as well. And what I had, my thought in going through this, because I had to scratch my head on it, and I feel that, you know, a letter warning should be issued to all of them and about this, even in light that the county, not the county, but the agency had submitted, had put out this addendum, because they, in their package that they included, they showed what the requirement, what they would be judging, using for their judging, and in the 4 or 5 categories, there was never anything in there about a fee proposal. So I think what the agency was doing is trying to cover themselves and not breaking the law with asking for a fee, but the firms did respond back, and you know, they one did take some precaution in it, but they need to be, I think the letter of warning should do it for them. And I'd just like to get some input from the other board members on this. I don't think a fine would be appropriate, but then again.
What did we do on the last case? I'm sorry, I didn't flip my
Go
card
ahead, I
up
saw
there.
you.
What did we do on the last case? I think we had, my colleague reminded me that we had a penalty, I think, on the one we had last.
$500 civil penalty.
$500.
That's our precedent. Law rule exam.
I'm not clear on exactly what they have violated.
Okay, in the art,
Jerry, I mean,
but,
did they all submit a fee with their proposal?
The 3 complaints two of them, and when you review their proposal, you can see their numbers are published clearly.
So they did
for
submit a fee then. Okay,
The third one put
his
his,
in the
yeah,
envelope,
third
but
one
two
put
of
in an
them did
envelope.
submit a fee.
Had they clarified that this was not their actual fee, some identifying it as just for budgetary, maybe something like that, to not indicate that this was going to be a working number, might have helped them out. I don't know it, but we state in our statute that when a public entity publishes an RFQ, that a fee is not to be used as part of the basis for selecting a firm, but it's against our statutes for doing that as well.
Rick?
Yeah, let me read into the record under the proper conduct of practice, the revised rule that we changed at the last rulemaking hearing is under proper conduct of practice 0120-02-.02, item 6. A registrant may not enter into a contract for professional services on any basis other than direct negotiation with the governmental entity that is prohibited by TCA 12-4-106A2A from making a selection or awarding a contract on the basis of competitive bids, thereby precluding participation in any system requiring a comparison of compensation. Upon selection, a registrant may state compensation to a prospective client in direct negotiation where architectural engineering or landscape architectural services necessary to protect the public health, safety, and welfare have been defined. That's the violation.
They can only discuss it after selection, not prior.
This is a question for that also. So if the agency had said, okay, submit your qualifications, and I'm just going to say the envelope, and once the selected firm is chosen, they've said, okay, you're our firm, your proposal has been selected, they could then open the envelope and start negotiations with that firm. They're not looking at the other firms. Is that acceptable?
After they're selected.
Oh, after they're selected. Okay.
I think there was a FAQ that recently you stated that they couldn't even do that. Is that correct?
Right.
So we're just contradicting what we're...
That's a draft for discussion. I don't know that the board has officially adopted that.
Okay. So at this point in time, if you supply sealed envelope that doesn't get opened before they make the selection, you're not in violation. But if you include a fee in your submittal, you are in violation.
No numbers in your submittal.
That's
No
my
fee
understanding.
numbers.
That's what this rule says. Okay.
Yes, Robert.
And one thing else that's a little disingenuous is there's evidently been a study already done on this jail.
No, this
Okay.
was, the RFQ was to do the study on the
Okay.
jail, and I guess the additional, the existing administrative space in that. And the agency was trying to get that in the RFQ, because as I said, the way they adopted a change because of a school that had been a school project, they stated that whoever selected to do the study, if they're awarded that, they do the study, but they would not be eligible to participate in doing the actual design work.
I have a clarification question to John. You said that this comment, no registrants may only state compensation to a prospective client in direct negotiation following selection, in response to the question about submitting a sealed envelope. That's not what
That's been my understanding from previous board discussions. I think that was the view that was being proposed, at least. And I think that's been TSPE's position for some time as well. correspondence that they've sent out to local jurisdictions. They traditionally have not liked the idea of submitting even sealed envelopes, so that's what the answer is based on. But again, like I said, that language hasn't been formally adopted by this board. It's still in draft form, so that's just a proposed response. Y'all can certainly alter that today.
I don't like the idea of allowing them to submit a fee in a closed envelope. You know, as a municipal employee, there's a lot of non-professionals who you can't trust those folks to not open them. They're going to get curious and open them, and just leave it the way it is. No fee, period. It doesn't matter whether it's separate or included. No fee, period.
Yeah, I pretty much agree with what Stephen just said. And when you think about it, what is the purpose? I mean, if you hire somebody, I mean, you select somebody and then you want to negotiate a fee, what does it matter whether you had in an envelope 2 days ago? And for the guys that didn't get it, I mean, it serves no purpose other than they could take it and look it up, steam the envelope open, so it really, I think not having that clarifies a lot of things for anybody in question. Can we submit a fee in a sealed envelope? Just say no, and then there's not a question about it.
We have a motion now for $500 penalty. And I guess what was the other?
Well, yes, sir. It was a letter of warning, a $500 civil penalty, and taking the law and rule examination. Taking and passing the law and rule examination.
I think what we've done now is we either assess this penalty or we close it. I don't think letters of warning are going to apply anymore because of our precedent. What y'all think? $.
We didn't do a letter of warning?
No, just a cover letter, which is warning enough.
They have to, do you recall if we required them to take laws and rules?
I'm almost certain we did.
He made it a part of it.
If Mr. Lim was breathing, we did, so.
Don't worry about it. I got it.
Steve?
It seems like even we are confused about whether it's okay to submit in a separate envelope. So is it appropriate for the one firm to get the same penalty as the one that submitted it with their proposal? So I'd suggest we think about that.
As the public member, I'm going to suggest that you will have difficulty with this whole situation as long as this board is in existence. Have any of you ever been an elected member of a public body, a city council, a school board, served on the public building authority, and had these kind of issues come before you, and you're not allowed to figure out how much somebody may charge you to do what you're trying to get done? I understand the other side of that, but I will suggest, in my opinion at least, they will figure out a way to get where they want to be and who they want to have finally. If it's no other way, it is don't submit a fee, negotiate, oops, sorry, your fee's a lot more than what we were intending to pay. We're going to move on to the next person. Oops, sorry, your fee's too. We're going to move on. I mean, they'll get there somehow. Now, I'm not saying it's not a bad idea to try hard. I'm just saying you're going to have difficulty with this all the way through from now on, because it is very difficult to write and have everybody understand exactly how this is supposed to operate. Even within the profession itself, I don't think is always clear on how they're supposed to operate. So I don't know if there's a way to clarify it better, to make it easier for everybody to understand, but we either need a lot more education about it or something, but it's going to continue to be a problem at every meeting, in my opinion.
to address that, Wilson, in looking at this, I had expressed my, when I responded back to Robert, I didn't quite get it across what I was thinking of, but had this entity gone out and talked to other agencies who have gone through this, they might have been able to get some feedback as to what a fee range would be for budget purposes only, or that the entity should have consulted with a design professional, had a separate contract, and give them some input so that they had it. But the way they went about it, with the addendum to clarify it and say you could either when you respond, you could either include a number, which would not be, and they would not consider that as part of the review process to determine who they want to award contract to. But it's a sticky, that's a sticky area. And I don't know if it's the board's responsibility to let public agencies know when you put these out. If you're needing budget numbers, go through engage services of a local design professional who can give you input. And if that's it, unfortunately, all three of them got caught between a rock and a hard place.
I'm sorry. Robert.
Oh, you were up. Yeah. I'm invisible.
You turned it where I can see you now.
See, that's what happened.
I'm sorry.
First of all, you're exactly right. If somebody wants to skirt it, they're gonna find ways to skirt it. I just want the board to know a couple things that are happening behind the scenes. I think that's the right thing. In this FAQ, I was asked to do some things that would clarify and help the process for both the contracting agent and the professional. And we've got a few things in there, and I'm not comfortable with how that came off. So what we've asked John to do is to try to get together with some people like CTAS, who's a technical advisory group to the counties, and MTAS, and some of those, and get some of those key people in and discuss, do we need to educate? Is there a process that would work better that allows them to have these budget numbers or some expectation on what fees are? Some of the agencies use standard fee schedules, like the State Building Commission has standard fee schedules. The Rural Development has standard fee schedules that they kind of use. And I just think a lot of it is some of the entities don't know these fee schedules exist, or they don't want to know in some cases, I'm assuming. But there is technical assistance available to city councils, to building commissions, to all these different entities that they can get budget numbers without having to hire a professional to do them. I mean, for instance, if you're building a new school in your community, talk to the school board in the next community that's got done building one, ask them what, how many square feet, how much it costs. I mean, you can get those kind of numbers if you're willing to do just a little bit and so I think our job here is, again, to protect the health, safety, and welfare of the public. I think these three were in violation. I agree with Steve that we've got a little bit of ambiguity on the way we're looking at it all. I think once this FAQ comes out, that will be clear. We've got to do more education. I got it. And we've got to do better at making sure people understand the benefit of making sure whoever you have is qualified, because the situation you talked about can happen based on our rules. We select somebody, your price is too high, we go to the next, but at least they're going down qualified firms to get to that next price. And that's our heartburn in all of this is, I know of a school north of where I live that they kind of went on the good old boy system to hire inspection services. And the county has actually spent hundreds of thousands of dollars correcting issues. Slabs were not poured level and things, water, moisture problems, that if they'd had somebody that was competent to do those inspection services, they would have saved themselves a lot of money. So we're trying to kind of keep some of that from happening. But I agree with you. If somebody wants to skirt it, they're going to skirt it. Our job is to get together with those groups that help advise and see if we can come up with a better way to build a mousetrap. And I just think that's your statement is very well put.
Now, we have a motion and a second. I think we've had a lot of discussion on this, and I know that we're going to have some more when we get into this matter further. I'm going to call for the motion. So all in favor, say aye.
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 Opposed? Okay.
All three, $500 penalty, law and rule exam,
Pass.
and pass it. All right, number 12, 2013-01812-1. This complaint alleges the respondent and the licensed engineer committed misconduct by providing professional services outside his area of competency and potential violation of our statutes and rules. The written reply from the respondent attempts to explain the respondent's role in producing these documents. These materials were forwarded to Ms. Reinbold to review for any probable cause.
I did have a chance to review them, and the facts seem to be this. 10 years ago, there was a footing inspection done by the county that had a note on it that it would be approved. The footing would be approved by an engineer's letter. The engineer subsequently did provide the letter of approval. Shoot forward to 2007, the house was purchased. Shoot forward to 2013, and there are settlement issues at the house. The insurance company had a geotechnical evaluation performed and denied the fix, covering the fix. The geotechnical report, their findings were, and this is why it appears to be denied, the findings were that there were poor fill, but also drainage issues around the foundation that could have caused the issues, and no sinkholes. So in September of 2013, the complainant filed a complaint with the AE board against the registrant, and who had done the footing and who provided the letter of the footing inspection. And the complaint is a little bit, there's a lot in it, but the thing that seems to apply to this registrant is that the complainant says that the registrant basically wrote the letter after the fact and did not perform. That's the assertion. The registrant's response to the board is that it was done properly, and at the time of the inspection, the footing met all the county requirements, and there doesn't seem to be any reason based on that and the letter provided. And he also had responded, and this was included with the complaint, a letter to a journalist. There was a story done on this, and the letter to the journalist also said that the inspection was done and was in keeping with their standard procedure. So with the facts based on what we have here, I would recommend that there's not anything that looks out of ordinary. Closer.
Do I have a motion or other discussion?
I did do anything.
I think the motion was to
Oh, I'm
close.
sorry.
Close it.
I
Steve's over here keeping me in line, so I just want you all to know it.
I agree with the recommendation that we close the case based on the information as presented.
Second the motion.
Further discussion? I have a motion and a second. All in favor say aye.
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 Any opposed? Motion carries.
All right, number 13, 2013-01837-1. This complaint alleges a respondent, licensed engineer, committed misconduct providing services outside the area of competence. Written reply from the respondent attempts to explain all that. The stuff was forwarded to Mr. King for review.
That's right. That's the one.
Oh.
You did instead of mine.
This is the one that ends in 837?
One.
Okay. this individual is a licensed engineer and has 5 previous complaints on. I don't have all that documentation, but it sounds like similar situations, and this situation is similar to the one that Mr. Wagster just described, where there has been some seals applied to drawings, and you can see tape lines where it appears to be stuck on. There's the building official in this case also filed the complaint. There's 2 different projects. One of the projects, all that was submitted was 8.5 11s of the seal area. So on that, I can't make any judgment about the competency. And on the second set, there are more complete drawings, but even then, it seems to me that the biggest issue isn't competency; it's the proper use of the seal. On the title sheet on the second project, there are 6 professionals listed with their discipline and their address and so forth. Only 2 seals occur. All the drawings on this project are stamped by the architect rather than the engineer. The engineer only stamps the cover sheet. But the drawings have the engineer's title block on it. So it's very confusing about, who really did the drawings, whether the architect actually put his own seal on the drawings. It just something smells a little off here. From what I have, though, it's difficult to know who did what. Engineer does assert that he was in responsible charge of the project, but he did not stamp any of the construction drawings other than the title sheet. And in his letter, he says he did. Evidently, this community has a requirement for a landscaping requirement, where you have to document there are so many trees on the site and that you didn't remove. He claims that's what he did. So his assertion is that he managed, I guess he would have put together this design team for his client and coordinated and got this set of drawings together. So that, I guess, sort of open for some discussion here. He didn't seal any of the design drawings other than the title sheet. But the architect's stamp looks like it has been improperly applied.
Robert?
Steve, there's no evidence on the title sheet or anywhere else that people said of that team, hey, I did this. I did, Mr. Engineer, I'm going to do the drainage, or there's no denoting
Right.
throughout the set that I took care of this piece of it. It's just, here's my team, but we don't know who did anything. Okay.
I did. Steve, the drawings that the architect stamped, they do have engineering information on them. It looks like they're all A sheets that I'm seeing as you flip.
They are A sheets.
So is there any engineering information on those
Well, this
sheets?
is one of, like we run into a lot of times in more rural communities. There's, on these smaller projects, there isn't a lot of difference in what an engineer and an architect will do and this board has typically allowed some of that overlap, but it appears to be more architecture than engineering to me.
So that seemed appropriate that the architect seal
Yes.
is on those sheets. It's just, did some of those sheets appear to have taped on seals?
All of them do.
Okay, there's taped on, so there's a question there.
Well, it appears that way. I can't really.
Okay. And then the engineer's seal being on the cover sheet, it's just not clear what he did because it's not.
The engineer seal doesn't. It looks like it was put on properly. There's no lines around it.
It's not clear that what
It's not clear
they're
what he
stating
did.
he had responsible charge of.
Right. Well, in his letter, he states that he had he was in responsible charge of the design development coordination, I think is his phrase.
I mean, no, I'm just asking for some help here. The way I understand that, because we are not discipline specific, if the architect demonstrate competency, he ought to be able to stamp every page. If he claimed that he can do it all. So has there been any attempt to pursue that, or is it something we had to open up and discuss about it? Since this architect is the one to stamp it, I would like him to write me a letter that says, I'm competent to design electrical system. That will be something we need to pursue then.
The architect?
Yeah, because since he stamped all every page of it, right? Now, I think that's a bigger issue than actually really this guy doing it, so.
Maybe that is the issue. If the engineer doesn't really claim that he did the design work, he coordinated it, then maybe our issue is with the architect, and it may be that the architect did not affix the seal himself. That's my suspicion.
I think it's kind of a little bit muddy right there. Thank you.
So maybe, would it be appropriate for us to investigate this with the architect? Or maybe we turn this into a complaint on the architect and investigate it, or I'm not sure what's appropriate at this point.
Open a complaint against the architect.
And then we may find out that the architect didn't know anything about it.
Possibility, you know.
And then we could come back and deal with this complaint.
What we need to do is defer this action on this until further information.
Well, rather than open a complaint against the architect, maybe we can do an informal conference or try to do some more information.
The respondent was the engineer.
Yes.
And so, and the architect was not involved in this. It was the engineer himself in the complaint.
Yes.
So if we investigate this further and find out the engineer maybe wasn't liable, but the architect was, we could close this complaint and then open.
That makes sense.
Yeah. Want to do an informal conference? Everybody involved?
I think that's the only way we're going to get to the bottom of it.
Take that motion.
Mr. Chairman, I make a motion that we defer this case for some more informal. Let the reviewing board member, Mr. King, to bring back the recommendation back to us.
Do I have a second?
Second.
Any further discussion? All in favor, say aye.
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 Second? Any opposed? Motion carries.
All right, number 14 is 2013-020-211.
All right.
There's a little bit of I think this, well, actually, Laura reviewed it. I'm just going to let you talk about it.
You want me to wade into this? All right. This is a community development corporation, public entity issued an request for quotes for property condition assessment. And the scope referenced ASTM E2018, which does not require professional services, although their guidelines do suggest it. And I know there's been some conversation about property condition assessments, but in this RFQ, it was really not specified at all that it was for professional services. And both the responding firm, so anyway, there were 3 respondents, and we have opened a case on one respondent who is out of Tennessee, has offices in Tennessee, and that responding firm and the public entity responded that professional services were not required or were not scoped for the property condition assessment. So, looking at it that way, you might be able to say, no, it's not a response. However, the responding firm in their proposal, and they all three, by the way, submitted prices, but the responding firm in their proposal presents themselves as providing engineering services. They, in a couple of different ways, so they say that the inspection report will be an engineering report, and the report will be issued by a registered professional engineer in the state of Tennessee. And then the two signatures, it's a two-signature proposal, and one of them is signed by a PE using their engineering license number. So that leads me to believe that they are offering professional services for this project and offering a fee for it. The second wrinkle in it is that the second signature on the proposal is by a person in the firm who does not, on their resume, appear to be registered as an engineer, and is not registered, definitely not licensed in the state of Tennessee, but uses the title senior engineer. So that was a real red flag to me. So for that reason, for this case, I'd recommend, and I think the precedent is the $500 fine for this. But the other wrinkle I have is that there were not cases opened against the other two respondents because they were from out of state, and yet one of them lists in their proposal that they have an office with engineers in Nashville. The other one, I didn't see anything in the proposal that they had an office in the state, and those two also offered fees, fee price, and in their proposal listed that they had engineers on staff. Now, they weren't as overt about the respondent that we're talking about specifically here, but it was their proposal was to some degree offering, in my opinion, professional services. So there's a couple of different issues here, but that's what I've gleaned from this.
Clarification, Laura. Was the company listed as an engineering firm or just your regular company?
It's the company that responded.
Yeah.
Yes.
So it listed themselves as an engineering firm.
It lists themselves as
an engineering company.
Yes.
So I guess question to the staff is that has it been verified that is this company properly registered with us, offering engineering services?
The respondent?
Yeah.
Yes.
I mean the company that he works for.
Yes.
Yes.
Yeah. Okay.
Yes.
Thank you.
The other ones were not.
Okay. The other one, are they in the same company payroll?
I'm sorry.
Are they in the payroll, or you say they are not listed part of it? They're not PEs, but are they employees of the company?
I don't understand your question.
The question is, are these people who are non-PE, are they employees of that company?
There's one person who's a non-PE, and he is an employee of the company.
Okay, that's
yes.
all I need to know.
Yes.
Motion?
So we've got one who's doing two things potentially: misrepresenting they're an engineer, right?
Possibly.
Okay. And then they are also in violation of the pricing statute. Okay.
Correct.
And then we have another one who says that we have a engineering branch in Nashville, and they're also giving a fee proposal.
Correct.
And the third one is
the third one I could not tell from the
semi-clean.
information I had and what I looked. I couldn't tell that they had a presence in Tennessee.
and I'm probably going to sound inconsistent, but I'll say it. This to me looks like a case where engineering services were not required. So I'm not sure that they were in, because I think our statute talks about engineering and architectural services. It doesn't say inspection services. Is that right?
References architectural engineering services, so that, but of course we don't define those services. So that's up to y'all to determine in this case if it constitutes the practice of engineering.
But the ASTM standard does not call this.
Correct. The guidelines suggest it, but do not require it. And again, the scope did not require it. What the proposal does is put them forward as providing professional services. That's why I brought that up.
Mr. Chairman, I got a point of clarification here. Isn't it when you are PE, whether you put the stamp there or not, whether you put comma PE or not, when you provide an opinion to the public, to me, in my mind, you're rendering professional expertise. Now, that doesn't mean because I did not put comma PE after my name or put a stamp on it, that doesn't relinquish me from my responsibility. The fact that I become a PE on paper, whether I carry the stamp, put on my forehead, walking around with it, I'm still a PE. So when I say something, that be my professional opinion. Obviously, I will not be the one that's going to give you a structural opinion because that's not my area of expertise. So, Mr. Attorney, can you comment on that?
Whether or not services are required, if you offer them, you're still bound by our law and rules. So if this project didn't require services, but services were offered or provided, they're subject to our law and rules. They don't get out of it. I mean, if you're exercising your privileges and rights as an engineer, you're subjected to it. That's my opinion. I mean, whether or not that particular project required it or not, if they're offering it, then they're engineering. Once again, it's up to the board as to what engineering actually is. We don't take other people's definitions for it. We decide.
Thank you.
Or do we have, what's your pleasure?
I guess my question would be, Laura, what's your pleasure?
I think it's a violation. I think they offered services, engineering services, and they.
I think.
So for that particular respondent, the one that the case was opened on, I would recommend the $500 fine and the laws and rules. You're welcome.
That's something I like about her now.
Yeah, I know.
Catch on pretty quickly.
I'm learning quickly.
I make a motion that we, and staying consistent, that we have a $500 fine, and that we that we request that they take and pass the law and rule exam.
Second today, Mr. Chairman.
Okay, any further discussion?
May I ask a question? Does that include anything about the second signature and his stating he was a senior engineer?
I think should be a separate complaint.
And then the other firms also?
We're just making a motion on this one complaint. All in favor, say aye.
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 Any opposed? Seeing none, that motion carries. Do you make a recommendation to open up 2 different additional complaints?
I just don't think we have enough information, perhaps not to, is my suggestion, that there's a kind of a red flag in both of those instances, this current firm and then the other firms.
Robert, how would you proceed on those 2 additional complaints?
What I understand, the other 2 are not registrants.
One of them is not registered.
Well, that's okay, but I think one of them is calling himself a senior engineer. Would that be a letter of warning or?
In Tennessee, you're not supposed to call it, say, engineer if you don't have the PE designation.
To be clear, I don't know that he's not a registered engineer in some state. I just don't, he's not a registered licensed engineer in Tennessee. And his resume does not have him listed, and another person's resume had them listed as a PE.
I talked to John about that, and it looks like we have a policy on that.
Yeah, we've got two policies actually that I think will come into play on this issue. One is the use of title if registered in other jurisdictions policy, which I know the policies are on your iPads. Let me kind of summarize what that policy says. It does state the statutory authorities that prohibit individuals from using the title engineer, architect, etc. in the state if they're not registered here. It goes on to say the board has determined that individuals who are not registered in Tennessee but who hold a like unexpired certificate of qualification or registration in another jurisdiction may use the title architect, engineer, or landscape architect, provided that the jurisdiction or jurisdictions in which they are registered is or are written or printed after the title so as not to mislead the public regarding their credentials. The listing of jurisdictions after the title is not required on correspondence, business cards, or other communication from an out-of-state office, provided that the individual is registered in that jurisdiction. So if he puts senior engineer on the letterhead for an out-of-state office, for out-of-state location where he is registered, then that's permissible per this policy as long as he's properly licensed in that jurisdiction, right? This would permit that. And we have another policy on RFPs and RFQs, design competitions as well. And that policy basically states that you don't have to be registered in order to participate in a design competition or submit an RFP or RFQ in Tennessee, as long as prior to participation you file an application for registration with the board and certify your intent to complete the application process. Should you win the competition or should you be selected? Of course, before you enter into a contract for professional services, you would have to be registered in order to do that. I think those two policies bear some relevance on this.
My recommendation would just be, there's just a red flag in my mind that he may not be registered at all and is using the title because of the way he was presented in his proposal.
Mr. Chairman, I think that based on what Laura's recommendation, I think we should at least pursue it. If it's innocent, then it's innocent. But at least we pursue it and complete it, close the case, because not forever will linger in our mind that no, we should have done this, should have done that. So, do you need a motion or anything? Yes. I make a motion that we open the case, complaint against these two registrants that Laura pointed out in this investigation, just to make sure that we go all the bases.
Second. Second for discussion. Okay.
What does opening a case entail versus sending him an email saying, we noticed in some of your documentation that you said you were a professional engineer. Can you please provide us with some documentation that proves that or something? Is that a lot simpler and less expensive than opening up a case? I thought maybe.
I mean, a complaint would be a formal process. We have, yeah, right. And it'll have to be presented to the board, and it may be a simple matter that could be resolved informally. In fact, in most cases, when someone refers an issue of this nature to us, like somebody using the title, or a firm that hasn't filed a disclosure form with the office, we normally resolve it informally by simply sending them a disclosure form to complete or educating them about the requirements of the law, and it's usually resolved that way, not through a formal complaint process. We open a complaint if they don't comply or respond to us, but otherwise we do it informally.
have to send an email, if it's all right with Laura, that go ahead and follow up with it too, to just for clarity, just make sure that these people are using the title correctly, where they're supposed to be. Mr. Campbell?
How was your second?
Well, remember the Robert rules.
I accept that, for that second.
Okay. Do I have any further discussion? All in favor of that motion, please say aye.
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 Opposed? That motion passes.
I hate to do this again, but is there any reason to ask the other firms who responded whether they have a presence in Tennessee and therefore would be subject to our rules and regulations regarding pricing?
Staff to just, that's not a formal recommendation. Go ahead and send a letter.
Rob, excuse me. Are you presenting the last one? Can I have just 1 minute to confer?
Sure.
All right.
Need a motion to take a break?
Yeah. Let's take a 5-minute break.
5 minutes.
Everybody back.
Beat time.
All right.
All right.
We're reconvening. Thank you.
All right, case number 2013-020381. This complaint alleges the respondent of PE committed misconduct through the use of the seal. And this was forwarded to Architect Board Member Mr. Thompson, Engineer Board Member Mr. Burnside, for review to determine if any probable cause exists for discipline. As a result of the review, an informal conference was convened involving all interested parties in order to determine further details as to the extent of the potential misconduct. There's no complaint history for this respondent. So, Rick, did one of y'all agree? And who's gonna lead the?
Yeah, I would like to open, and then Ricky's going to make a summary, just as this relates more to an engineering issue than it does an architectural issue, even though both were involved. So, as Rob stated, on 11/22/13, we had an informal hearing on an assisted living facility that had constructed, or where a deck had been constructed on the building. In attendance were the architect of record, structural engineer of record. The owner participated via phone, a steel fabricator, and miscellaneous steel contractor. The complainant engineer from Arizona, Steve Baker, Bill Harmon, Daniel Pace, Craig Parisher, and Nelson Rodriguez from the Tennessee Department of Health. So you can see that they took this very seriously. They sent the department head and 4 other individuals. Also in attendance was Francis Smith, John Cothran, Robert Herndon, Ricky Bursey, and myself. And with that opening, I would like to turn it over to you, Ricky, to let you try to summarize this. It's was a very complicated.
I apologize in advance for the length of this, but there was a lot of documentation for us to go through, and then we had a lot of people in on the informal conference. So this is my best effort to summarize what happened based on everything that came into us, and may not be exactly right, but this is the way we understood it. The owner of the nursing home hired an architect to do the plans for the deck and an extension of the roof. And plans were done that included architectural and structural sheets, and those were bid, and or those were put out for bid. And according to the owner, she got no response, no bids, nobody a bid, no contractors. And the input she got was that the structure shown for the deck was steel and that was overdone. It should be cost and I guess their opinion. So it appears that she asked the architect.
Ricky, I can't hear you.
Okay. According to the owner, she asked the architect and his structural engineer to change the design to wood, and they refused to do that. They felt that the steel was appropriate. So it then appears that the owner hired a general contractor directly to provide a design build and dismissed the architect and the engineer, according to her. So the general contractor hired a steel fabricator, who then hired another structural engineer from Arizona, to look at the design that was done and to provide calculations in an alternate design that they could look at to appraise this change to a wood structure. That might be our caterer, I'm not sure. So the steel fabricator sent drawings to the Arizona structural engineer. They weren't the final bid documents. They were preliminary. They were a set mark preliminary that had dates that looked to be about a week prior to the final. So they looked like they had all the information on them, but they were definitely identified as preliminary, not for construction. So the Arizona engineer provided several 8.5 by 11 pages of calculations and drawings, and taking the drawings that were given to him and showing what changes would be needed to go to a wood structure, and put a stamp on that and provided that to the steel fabricator who hired him. It appears then that steel fabricator submitted those drawings to the Department of Health to construct. Now, prior to that, somewhere the construction had started, and the wood structure was installed that didn't match the design drawings that were done by the original architect and structural engineer, and it didn't match what the Arizona engineer had come back with. There were differences there. The Department of Health has jurisdiction here, and they, on several field trips, they noted on their field report that the construction did not match the design, and they were looking at the original design documents. So there was an issue there that the Department of Health was aware of what was going in. In addition to that, there's some pictures that look like there some potential problems with quality of what was done, quality of the concrete and in the foundation. The Arizona engineer, as the respondent here, complaint was issued against the Arizona engineer. He did not know his drawings were being used or submitted to the Department of Health as construction documents. So that was a surprise to him, and he didn't know the status of what was going on in the field. The construction's now at a standstill. The Department of Health is not going to allow occupancy, and so the owner is now contemplating how to move forward with something that is in place but appears not to have been designed by a professional engineer, as to whether what was put in place can be somehow altered to meet its design. To hire an engineer who would say, yes, this is what you need to do to make the structure safe, and to install that, or to tear it all out, start over again. That's where that sits. So we looked at, after the informal conference, we talked, Rick and Rob and John and I talked and looked at the rules. And Rick, we've got, I guess I'll turn it back over to you both if I missed anything in that summary, and for what our recommendations are.
Quick question. The building permit that was issued for these facilities, what plans were used for those?
They were the plans of the original architect and structural engineer that showed the steel.
Thank you.
And they were approved, and then each inspection, they had, we have reams of photographs that Francis has on record that the State Department of Health took in continuing to deny them the ability to get a CO on that structure. It's in question. The engineer of record would not touch it, which I don't blame him. The architect of record wouldn't touch it, which I don't blame him. The engineer out of Arizona who did the calculations based on preliminary drawings will not touch it, and I don't blame him. And so apparently the contractor has found a structural engineer who's willing to go out there and do an as-built and sign off on it if some conditions are met. That's what we've been told. I don't know if that's the case. Ricky?
I left out one important item. The Arizona structural engineer provided the calculations and some plans that show somebody altered his paperwork because what was submitted to the Department of Health, you can see some rough pencil additions that are obviously in another hand and done in another weight and that sort of thing, and it compares to the Arizona structural engineer's original. Somebody added and apparently was not a professional, because there's no other stamp on there other than the Arizona's engineer. So we have that went on, and what we tried to get to the bottom of that in the informal conference, and the closest we can pin it down is that the Arizona engineer sent his originals to the steel fabricator. The steel fabricator submitted these structural drawings to the Department of Health, and somehow with the additions appeared on it. So we drew a conclusion that it's very likely that the steel fabricator altered the drawings.
And the State Department of Health agreed with that. They rejected those and asked for a proper submittal, which I think anybody that has done work with the State Department of Health knows that they're very particular about what you submit. And they requested that another set of documents be submitted in the form that the original submittal was, which was complete architectural plans and complete structural drawings with a seal from an appropriate registrant. It remains to be seen if that's going to be the case. Kind of in a nutshell, to me, this was a bait and switch type operation where some contractor came to the owner and said, "Oh, that's too expensive. You can't afford that. I can get it done cheaper." And then enter all the players who are trying to go around the back door, and here's what's happened is now they got a structure they can't occupy, even though the client or the owner said in the hearing, "Well, I think it's going to be just fine because there were some cushions out there on the deck the other day. We had a windstorm and they didn't even blow off. Now, why are the cushions out there? They're occupying the structure and they don't have a CO."
Sunbathing.
They're sunbathing, yeah. Nudist colony but it's just a really confusing. I don't know how they got to where they are, but it's certainly it's not a safe structure in our opinion. So,
Rick, who is the respondent in this scenario? Is the structural engineer that was hired by the general contractor? Is that who this complaint is against?
yes, and we filed the complaint, right, based on the information we got from Department of Health. So the complaint was opened by staff. They reported it to us.
It's a structural engineer that was employed by the general contractor. Okay.
Was the Arizona engineer licensed in Tennessee?
Yes.
Okay.
Right. Well, in y'all's discussion, did it come up as to why the original architect and engineer refused to change to wood?
Go ahead, Rick.
Yes, it did come up, and they felt like it was not in the best, in their professional opinion, that was not the approach to take. That they were concerned about the integrity of the wood structure, and that structural steel engineer quoted that he was not prepared to make those changes. So, and at that point, I believe the architect and engineer of record were terminated by the owner, and then this other weaving and bobbing occurred.
The recommendation.
We have recommendations. We have 3 recommendations, and after the conference occurred with Ricky, myself, John, and Rob, the Arizona engineer, we were looking at certain rules that he may have broken, and after looking through the rules, the rule 0120-02-085B allows him to do what he did since the original designer was terminated. At that time, we thought he might have been altering drawings that he saw them as on a preliminary basis, and he didn't know that there were structural, I mean, they were sealed and submitted by the state. He was working for an individual that, and that's was his understanding. Additionally, Rule 0120-02-08-6B, because plans changed weren't final, they were clearly marked preliminary. That's why we don't think he broke that rule. What we do recommend, though, is we write a letter of caution to the Arizona engineer, because while he didn't break the rules, he should have done more due diligence to know his design wasn't being changed or used when he didn't intend it to. Also, make him take and pass the Tennessee laws and rules. Thirdly, we recommend to the AE Board that a complaint be filed against the steel fabricator for violating 62-2101 by unlawfully practicing engineering. In our opinion, he's the one who modified those calculations, of which he was not very forthcoming or cooperative.
Robert?
Question for about the Arizona engineer. What format did he submit his preliminary plans in? Were they in a CAD format? Were they in a PDF format? Were they in a hard copy format? How did he submit those?
Go ahead, Rick.
Oh, go ahead, Rick.
They look like they were 8.5 by 11 hard copies that then somebody made a PDF file of and sent to us. So there were calculations as well as reduced plans that he had some information on and some detail.
My comment my comment to that would be, I don't know how much more he could have done to keep somebody from changing. That would, because that's something that we all face every day. is when we publish a set of plans, anybody can take them and write on them whatever information that they want to. I mean, I just.
Well, the
I'm
point
trying to
is,
see I'm trying to see where he messed up on that.
well, the point was not that he did, that he made the changes. What he did was he took some preliminary drawings and made the value engineering design, which again, he should have done more due diligence in what he was doing, but he was provided a set of documents that said preliminary design. And there was one note on there which we all took exception to. Where is that, Ricky? About the and they used this to their the contractor used this note to his benefit, which the architect of record when he talking to us took exception to that, in which I don't disagree. Do you know where that note is, Ricky?
The note on the drawings.
Yeah, but which number is it?
Yeah. There was a note on the original architectural drawings that said, I'll find it here, but to summarize, it said that these drawings are for the sole use of the contractor to use how he sees fit. A statement like that could be interpreted as giving a contractor more leeway than normal.
But then again, the architect of record took exception to that, and so do I.
Right. That was not the architect's intent, and we made that clear in the conference.
So I think to answer your question, Robert, what the Arizona engineer did was he didn't do his due diligence, but he was provided information that was not current. He didn't know there was a permitted set, and that they were under construction, and as a matter of fact, the construction as done today does not even, it obviously doesn't match the structural engineer of records drawings, nor does it match the supplemental engineer's drawings, and they are just, it's just, a hodgepodge.
And Robert, you make a good point. And looking at what the way things happened in the rules, there isn't really something that we think that the Arizona engineer did wrong, other than we were left with the fact that maybe he needs to choose his clients more carefully, because the steel fabricator seemed to so blatantly do what he wanted to do without any regard to a registrant designing some structure for a nursing home, that we wanted to send some message to the Arizona engineer that, please watch out who you work for, because that's part of and so maybe a letter of caution isn't the right, maybe that's not the right means to do that, but that seemed to be the lightest letter that we could send him.
Weren't y'all saying, were you saying to fine him too and have him take the law and rules or something?
No, we said letter of caution, send him a letter of caution and ask him to take and pass the Tennessee laws and rules.
Think he violated the Tennessee laws and rules?
No, that was just a Philip Lim. It's good for everybody. It's like, your
I'm
vitamins.
He took him
it's like your vitamins every
to
day.
get his license, didn't
he? I'm sorry, say that.
I mean, I'm assuming he has taken that at some point in time to be licensed in Tennessee. Is that correct?
No, there is no.
You don't have.
We don't require people to take and pass the test when they become an. and everybody in every state may have their own little rules, and so it's just kind of a healthy thing and out of respect. But it's
I was going to.
you're right. Your point is correct. He did not appear to break any rules.
I think Wilson, you're correct to say that, but the most important thing is that this is one way to educate our people, because this is a way to really actually when you sign the affidavits every time when you renew a license, it says did you read the law and rules, and most of the people sign a dollar line means you had to read law and rules, so this is an emphasis for them to allow them to kind of have a chance to go revisit some of the rules, especially on the professional conduct. Nothing else to get their attention that hey, choose you're applying carefully in the future, or certain things you need to be aware of.
I feel a little bit bad about the Arizona engineer. If we're going to say that he didn't do anything wrong, any design that any of us do and put our name and seal on it, anybody can get a copy of it and try to, through fraud, change it. So I'm not sure that we need to put a mark on his record with a letter of caution.
Time out. Wait just a minute now. Time out. Sir, I don't know who you are. I don't really care. But this getting up, walking back and forth and passing notes does not help us in this discussion. And when we get to some point, we can do that, okay? But we're talking among ourselves right now, trying to get the facts. And this up running around stuff is bothering the hell out of me, just to be honest, okay? So just calm down. You'll have your day in court when that time comes and if that time comes. But we're trying to discuss an issue here. So my thing is, I would, my motion would be that we open up a complaint against the steel manufacturer, and we have nothing against the Arizona engineer. That would be
The basis would be
falsifying documentation.
unlicensed practice?
Yes, sir. Yes, sir.
Okay.
That would be my motion.
Do I have a second?
Second.
As
Any
far
discussion?
as disciplinary action on the complaint, what's the recommendation?
Since we can't find.
Well, this motion, we would need to
Yeah, let's take a
take a vote on this motion to open up the complaint against the structural steel guy. Let's move on that motion. Any further discussion on that motion? All in favor, say aye.
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 Opposed? That motion carries now.
Now tell me how I'm wrong.
No, you're not wrong.
Now,
Go
how you
ahead.
resolve this on the,
Before we get to this, there's one other thing that has been discussed, is that possibly writing a letter to the Department of Health and thanking them for their assistance and letting them know that as a board, we feel like the structure as constructed is not safe, as it does not protect the health, safety, and welfare. And they noted to us in the 20-something years that this Mr. Harmon has been working with them, they have never forced the destruction of a structure. Now, they've had modifications that had to be made if they wanted to occupy it, but this is a little different. It's a deck, and whether they're using it or not, they can't run out there and look at it every day. Somebody else has to do that, and I don't know if that's a function of the board. Do we have that ability to? I don't know where to go with this, other than I would like to at least have something on record that we are concerned about the health, safety, and welfare of the residents. And if you know what assisted living centers are, that's very frail residents.
Suggestion is probably what we need to do, because we're not the codes people, but advising them that we feel, in our professional opinion about what we know about design data of this particular structure, that we recommend that you keep a tight watch on it.
Yeah, something to that effect. Does that need to be a motion?
It's always better if it's a motion.
What can I make that motion, Mr. Chairman? I would make a motion that we write a letter. The staff writes a letter to the Tennessee Department of Health expressing our concern on the quality of the construction, and that we are worried about the health, safety, and the welfare of the residents, and fill in the blanks on that. So leave that to staff to complete that letter.
I'll second that and add I think you said earlier, add a note about their diligence. We thank them
Oh,
for their
yes,
diligence.
yeah,
in this.
thanking them for their
Yes.
due diligence.
Yes.
That's correct.
Yes, yes.
Because again, there were 5 of them here, for
Concerned, yeah.
very concerned, as they should be.
Any further discussion on that motion? Seeing none, all in favor, please say aye.
Aye.
Opposed? None there, so that motion carries. Now back to the original case against the
new guy.
the Arizona architect or structural engineer.
Yes. Our complaint there is that, or our recommendation there is that we found he did nothing wrong, didn't break the rules. I thought Robert made a motion.
He did?
He's already made a motion that covers that.
Okay, yes.
A letter of caution and laws and rules exam.
Would you step up to the microphone if you're going to speak, and please keep it short? Thank you.
I was not released from that project. I'm the architect of record, Mark Hawks from Jackson. I was not released from that project only until maybe about a month ago. And the Arizona engineer stamped his final drawings and used our drawings and used my name on the front of his drawings without my permission or my structural engineer's permission. He says in here that these calculations are based on the design drawing specifications, wind seismic design data provided by the contract documents prepared by Mark Hawks Architect, Jackson, Tennessee. Did he take that design data off preliminary drawings and use them? He didn't provide foundations nor piers for this design either. So he didn't provide a full design, especially if he only had preliminary drawings. So is he taking information from preliminary drawings of ours and actually using it, using our name on his documents? And there's a letter that I just received a few minutes ago that 10 days ago, the same engineer is wanting me to participate in them for the correction of the canopy foundations and things. So as architect of record, engineer of record, for the steel design, the reason we didn't do that was because the existing building drawings did not even include a basement plan and were overstamped by another architect. And that architect stamped mechanical, plumbing, and electricals, and the sprinkler design.
Excuse me, this is not what we're discussing here today.
But
thank you for your
the
comments.
question was why we use steel, because we didn't want the loading to go back into
We
that
don't
building.
want this to get off track.
But the Arizona architect used my drawings and my structural engineer's drawings and put his calculations right on top of them and did not get our permission. And I've got multiple tape conversations with them over the months.
He included in y'all's meetings?
Informal conference,
He was,
yes.
now that he's identified
This is a
himself.
Department of Health document. And, but if he can use my name on the front of his drawings and say that he used our calculations and wind loadings, can I do that with other engineers?
Excuse me, Mr. Chairman, I think that if you have concern that, I think it'd be good for you to file a formal complaint through the board so we can open a case, then we can talk about your case.
I've been talking with them for...
No, I think file a formal complaint through our board, and then the board can formally handle your case because we just don't want to muddy up the situation here.
I've been working with John and Francis for 3 months on this.
So,
Can you take the advice of the board for you to open a complaint because you're talking to someone doesn't mean
They've got all the documentation.
Well, then file the complaint.
Just file a complaint, and then they can give you a complaint number.
Ricky?
One thing, just to respond, what we looked at, and again, it was kind of a tortured process that we, through the informal conference and documentation, tried to figure out what happened when. But in in our rule that Rick cited a bit ago, let me just read this so you can. It says, in circumstances where a registrant can no longer provide services on a project, such as death, retirement, disability, contract termination, a successor registrant may perform work on a set of plans originally prepared by another registrant. If the plans are incomplete at a stage prior to submittal to a reviewing official, the successor registrant may not seal the set of drawings prepared by the original registrant. Rather, the successor registrant must take all steps necessary to ensure that the drawings were prepared under his or her responsible charge. If the plans are complete and have been submitted to a reviewing official, the successor registrant may prepare and seal addenda sheets if revisions are necessary. We felt like the Arizona engineer was responding to a restricted request by his client and provided in what he thought were preliminary drawings. And we feel like the culprit was the steel fabricator and the contractor who took those and made those into contract documents to build by, which were not the intention of the Arizona engineer. And the Arizona engineers cooperated has been very open and free to respond to our request for information.
This is a letter from the Arizona engineer of October 17th.
Is that part of your record?
I can't remember if that was part of it or not. I know there were several letters from the Arizona engineer.
He's including me in the corrections.
That's not part of our evidence.
But part of the evidence is that I've submitted to the board is that I was included in everything up until just about 3-4 weeks ago. So they made the changes to all these drawings, and I was not terminated.
The owner said you were terminated in the
I've
conference.
got documentation that she didn't.
Well, okay, can we call this?
Yeah.
I mean, we voted and we've heard enough. Thank you. File a complaint if you'd like to continue this conversation because we're through.
Thank you.
Mr. Attorney, too, I'd like to ask a parliamentary question. I think we in times past have had anonymity on respondents and complainants, and that's one of the things that hopefully has allowed us to make impartial decisions. If this complaint is open, and I think it should be, it sounds like there's either new information or information that was could have been overlooked or questioned, whatever. How are we going to maintain that anonymity now?
It'll be tough.
Yeah, that's what I thought.
And if we do open a complaint, I'll recuse myself from reviewing it. You've got my opinion, and I think, Ricky, you do the same, would you?
That's another matter. Now,
They also have to make I'm sorry, Mr. Chairman.
have we actually voted on this recommendation?
I think we voted on a recommendation for this respondent. Last I heard, there was a letter of caution, but I don't know if that.
Modified, right? Did you want to make the?
No, Robert says no rule.
Let me restate the motion. My motion was that we open a complaint against the steel manufacturer.
We voted on that.
And we voted on
Correct.
that, didn't we?
Right,
Okay,
yes.
and there was no action against, I think my motion had no action against the Arizona engineer as well. It was a two-part motion.
A little unclear as to what a further complaint on this particular matter, other than the one that for unlicensed practice. I'm not sure where that would go or the purpose for it. I mean, what does the board expect to find out with another complaint on the same matter?
Let it be stated, and then we'll review it, and we'll, either accept it or dismiss it. It's just that easy.
I think the normal procedure is if there's new evidence presented that wasn't considered when the complaint was originally
It would have made a
reviewed,
difference.
right, then we would reopen the original complaint typically rather than open a new complaint. Right, Rob? Is that
Yeah,
correct?
that's when we close them rather than dismiss. When we close and new evidence comes up, then we can revisit the matter, rather than open a new one and duplicate and send letters out for responses to the same people that have already responded and so on and so forth. It just seems like a duplication. But of course, it's up to the board, whatever you want to do.
But the new complaint we're filing against the
Steel guy, that's different.
right.
That's
But
that's a
if
different
additional
issue.
evidence that is submitted appears to be
That's different.
pertinent
That's-
enough, that would reopen the complaint. Is what you're saying instead of filing a new complaint.
Right. Yeah, we could just
I'm fine with
reopen
that.
the existing complaint.
If the evidence substantiates that,
right,
and that would be up to you, right? From yeah,
consultation with the attorney.
Yeah.
If new stuff comes in, I'll talk to John about it and see if this is a game changer.
Okay.
The new complaint against the contractor, I think, is valid because it looks like there's potential he practiced engineering by doing what he did, and that's not addressed in this complaint specifically, and that needs to be addressed on its own. This complaint, I think, we just leave it as it's
We can go
I'll
on.
dismiss it, yeah.
Okay. So let's move on to the next item.
What was?
What?
I'm sorry. What was the final recommendation for this complaint? Just so I know.
That was part of his motion.
The motion that was approved was to file a complaint against the steel manufacturer and to have no action against the Arizona engineer.
We're gonna close.
Yes, sir. But understanding that you have the option, as you do on every case that we hear, of reopening it should new evidence come about that's pertinent to that. I mean, that's a standard with every case that we have that we dismiss. If new evidence comes in, we have that. I'm still, I'll state my original, this thing of anonymity and of prejudice of the evidence bothers me about this board being able to make an effective decision later on should that evidence come up.
That's why I didn't want to open a new one. If anything ever did come to a formal hearing, we'd probably have to have a judge alone. There would be no panel. You wouldn't hear it because now you know too much. Because the purpose of this is to find probable cause, not to hear all the facts. That's what formal hearings are for. Because this is a public meeting, I guess it was appropriate to allow the public to speak if they feel they have something to add, but this is the danger that we run. Complaints get sunk that way.
All right, let's move on to the strategic planning discussion.
Is lunch on the way, I guess, or?
I don't know, nobody has called me.
I mean, we could break for lunch and then pick up after lunch if you would
Well,
like. Or,
Is the lunch people here?
I don't know. They'd be delivered to 6. Is it up there? Do you know?
Francis was.
I don't know if it's here yet or not, but we can check and see.
We were thinking we'd be done by now, but
He
we're
should be
not.
here. I talked to Howard City. He'll be here by no later than noon.
The one that can go check on the lunch, and then I can proceed with the strategic planning discussion if you'd like. That's on page 18. All right, in the interest of time, we don't have to spend a lot of time on this. It's really up to y'all. I'll point out to you the results of the mega issue identification survey. The top issue that was identified as being a mega issue for the board's consideration is mobility, addressing different requirements among states. The second issue was upholding standards, pressure to lower standards. And then thirdly, devaluation of licensure, design professions viewed as commodities and economic pressures. So normally at this point, you would probably identify preferably one, you could do more than one, issue to develop further. And you would need to articulate that as a question in the form of a question that would not be answered with a yes or no, and then identify possible sub-questions and create a background paper that would identify choices, and then you could create action steps based on that discussion of the background paper. That paper could be prepared by an individual, a task force, whatever is the pleasure of the board. So you're free to discuss.
Members? Frank?
Yes, and I know that the first one listed as a priority, the mobility and the addressing different requirements among states. And I think we've taken some steps already to address the architecture. And I'm referring as far as continuing education goes in this case, but we're making progress, I guess you'd say, in by just having the year being the January through, rather than at your birthday or whenever it is. And so part of that, where we are already working to address us, the engineers as well. So I guess the question there is, if that were our, and that appears to be the top number there, that be a problem we're selecting that we're already addressing?
I would say that I'm sorry, I didn't raise my point.
Sorry, John.
Okay. I would say there's a lot of issues that still remain to be dealt with in the area of mobility, particularly for the landscape architects, not to pick on y'all, and the engineers, because their educational qualifications are so narrow and strict, especially the landscape architects. It's either an accredited degree or nothing. So it's pretty narrowly defined. So there's certainly some areas under mobility that could be addressed. I think the majority would require statutory changes. It couldn't be accomplished just through a rule change, unfortunately. And that's difficult in and of itself, trying to make a law change. But I think that's certainly something that needs to stay on the radar.
I'm not sure that's the most critical.
Well, it's
item.
The numbers are so close, 6.33 versus 6.17. I mean, it needs to be on the radar screen.
Yes.
But I mean, you're right, Frank. Is it number one? I don't know. It's just one of the top four. So maybe they're all equal.
Now, I do agree that the law change will be difficult, but however, I think we can streamline some review process. Like, for instance, take the engineer. On model law now, the board actually approve the directors to actually go through the first cut of it, and we just sign off on that because that was allowed, but because we did that. The other thing was that we talk about the laws changes that where we had to give preferences to expedite the application for people in military services or the spouse. We as the engineering committee yesterday talk about that. Really by the time we issue a temporary permit, it'd be quicker for us just review it and turn it around within a week to give that approval. So I think administratively speaking, I think we can improve on that process if we just at least for the low-hanging fruits. That's my thinking.
One thing you bring up, and it is a question. I've seen all the verbiage about the military and expediting, and that's a good thing. And I think that's probably coming from the governor, from what I've heard. Don't know that legislature,
ultimately.
But how does that? How are we affected by that? I mean, are there just dozens of these, or are there one or two, or none? Or
I haven't had anyone even ask questions about it at this point. So I doubt we would have very many apply under that provision. Very few, I'm sure. Yeah.
I thought the same. I don't mind helping the guy that's, fighting our wars for us. But at the same point, it's not a huge issue we need to deal with, I guess.
The strategic planning, that can be an ongoing discussion that we can,
I think
place on
those
the
two
agenda for
items-
the next meeting if
I
you'd
think
like.
let's do that.
Since we have other issues on
Yes. Yeah.
Lunch is available.
So, is everybody willing to break for lunch? Are you guys hungry?
Chairman, can we make a motion to adjourn for 45 minutes lunch?
Yes.
About a 30-minute lunch.
30 lunch. Okay, I'm glad to. I'll be glad to.
Yeah, 30-minute lunch. And by the way, I will not be here after lunch, so the vice chair will have to take up the.
How many do we have to have for a quorum?
We have to have 5, right, Wanda? Yeah, 5.
Wait, now. No, I got a motion. Do I hear a second?
Did I hear a second? To break for 30 minutes for lunch? All right. All in favor, say aye. All right.
Aye.
Okay. Susan, we'll catch you on the back.
That's right.
Okay, John, I'll call back in 30 minutes.
All right.
Okay.
What happened to my mic?
Yes, we will. So we just leave our stuff here?
I was hoping the strategic plan.
Take them out
While
first.
they were fresh.
I know.
John, everything will be okay to leave everything here?
I just realized I have a plaque. I have a name.
Okay, we are re-adjourned.
I'll take a picture of that and show my kids.
Where did we
Seriously.
wind up?
Right now.
All right.
Like mom has arrived.
We are,
Oh, where's my,
here on director's report, Beth.
I know, but my second page is missing. So, you got yours, right?
Show my kids. Don't give me a
Should have
lip.
thought of that.
That's right. I have my own name tag.
Oh.
I'm gonna show my kids.
Quorum, do we need quorum?
Yeah, we have it for them.
Yeah.
We have, even when Wilson leaves, we have 1, 2, 3,
Yeah, we're going now.
4, 5 votes, yeah.
6.
Susan's here.
Okay.
Okay, we're live.
Welcome back. We've reconvened the meeting. How'd you like your lunch?
Feeling that bowl of vegetable soup was awesome.
Great.
I got my mother's doctor report and a vegetable soup. How about that?
You're in good shape. Okay, we're going to resume for the, we finished the strategic planning discussion. John is still up on the deck, and we've got the director's report regarding the complaint data and the financial data. Mr. Cothran?
Thank you, Mr. Vice Chair. A few other things to report before we get into the complaint data. Susan Ballard and I attended the CIDQ annual meeting in Las Vegas on November 8th and 9th, and we'll have a report on that later on the agenda. Hal Bothrop spoke to engineering students at Lipscomb University on October 21st. I didn't hear anything bad about that, so I'm assuming it went well. I will also speak at a Memphis Light Gas and Water seminar in Memphis next Tuesday regarding ethics. Philip, are you going to be in attendance at that? Or? Okay, so I'll direct questions to you.
That's fine. They know where I stand, so don't worry about that.
Okay. Other issues, the rules adopted at the August board meeting have been refiled with the Attorney General's office. They were returned with some comments, so we had to refile those recently, and they're currently under review. Hopefully we'll hear back from them fairly soon. If we hear back soon, then a March effective date is possible, but it's all dependent on how quickly they return them to us. Grant contracts with the schools have been drafted and are currently under review, and we anticipate an effective date of February 1st for all of our grant contracts with the schools. Another issue, administrative issue I wanted to ask you about, for years, as long as I've been affiliated with the board and Wanda, the board staff has always made hotel reservations for board meetings, for in-state meetings for board members. It's just come to my attention that very few of the regulatory boards offer that service to their board members. Actually, our board and the real estate commission are the only two that do that. And I know some of you have special, what's the term for it? Reward. Thank you. Reward programs with certain hotel chains. So I just wanted to ask if there would be any interest in perhaps just allowing you to make your own reservations, and then you could pick whatever hotels you prefer, and that would relieve board staff of having to make those reservations, which recently has become a little more burdensome than it used to be. I think partly with the convention center coming in, it's a little harder to find hotels in the downtown area than it used to be. So I just wanted to ask if there was any interest in doing that. If you do make your own reservations, we can provide a list of hotels that have the state rate. So what are your thoughts on that? But certainly for the retreat, though, I mean, we would, I think, still do it for the retreat.
February has been settled, right?
Yeah, February's already reserved, yeah.
Well, just as, will we know far enough in advance if we're going to need 2 nights in the event we have?
I think so, yeah. And certainly if a meeting is canceled or something, you would have adequate notice where you could cancel the reservation without incurring any penalty for that.
I don't know about anybody else, but speaking for myself, 1 or 2 nights on a Hilton Honors or a Marriott Rewards or whatever it is, it doesn't make that much difference.
Doesn't help much.
It's been my experience that if you get a state discount, you don't get the rewards points. So
the truth is, Wanda threatened me if I didn't ask y'all about this. I'm just kidding. No, not really, not really.
I appreciate her doing it for us. I don't complain about where she puts us. I think it's very nice to have that assistance. So.
Yeah, we can continue to do that. Certainly, us and the real estate commission can continue to offer that. So.
I'd just like to note that Susan mentioned, she said that, and she's not within arm's length here. She can't be struck.
Yeah, that's great. Yeah.
Way to go, Susan.
You're mistreating you.
You'll get me later.
Question then, are we obligated to stay at a hotel that has a state rate?
No, you're not.
No. Okay.
You can stay anywhere.
It's just the state reimbursable is what we.
Right, you'll only get reimbursed the state rate, but yeah,
like this
stay
time.
somewhere nicer if you want.
I think we don't have to decide right now because February is taken care of.
Right. Y'all could.
We're going to decide February.
Yeah.
Y'all could we could do a survey and see.
We could put it on this.
Hey, why didn't you ask a question before I give you a
mega
lunch?
issue.
Mega issue?
That seems like a big mega
I want to
issue.
do a monkey survey.
And we can talk about it for an hour.
Yes, exactly.
Yeah.
We'll be thinking on that.
Thank you, Wilson.
Yeah. Exactly. So we got reservations for February, so we'll need to know pretty soon, I guess, whether to do them for April. Page 23, you have complaint data. This is just a snapshot of our open complaints as of November 25th in this case. And you can see that we have 20 over 180 days old. That's just looking at the date that they were opened in our system. But none of those have been open over 180 days without clock stopping action. They've all had their clocks stopped by the board authorizing a formal hearing or consent order being proposed or something of that nature. We've got 9 hearings authorized to be heard by the board, 11 by an ALJ, administrative law judge. And our percent on time in the last 18 months is 98.78%, which is obviously very good. And behind the complaint data, we have the financial report, which actually I should have had Robert's name on that since he's the secretary, but I can summarize it if you'd like. Or
That's fine.
revenue, still doing good. Actually had a slight increase from the first quarter of last fiscal year. Expenses remained largely consistent for the most part. Personal services expenditures did increase, but that's due to our massive wealth expended on our salary increases largely. So, yeah, we did have a salary adjustment that took effect in July of this year that increased our salaries, significant amount. So that's partly why the personal services expenditures have increased. And as I said, other expenses, I don't think there's really any surprises there. And our year-to-date reserve for this fiscal year is $248,090. And you will note our office space rent charge is being reduced since we have moved into smaller accommodations. Yeah, teeny tiny office. No. And then you have the detail behind the summary if you want to drill down deeper into the expenditures, into the revenue by month. And that's just available for your information. It doesn't require any action on your part. Right, the assistant commissioner reported on our expenses and revenue for the last fiscal year that ended in June. So I will entertain any questions if you have them.
Not a question, but a comment. Thank you for bringing him up to speed on where we are from the engineering side on the FE. I think that's something that we continue to be a little concerned about going forward, from continued registration and how that impacts our registrants in Tennessee, and B, our financial situation as well. And in that light, and this is probably a quick financial committee part two as well, Rick, we will probably continue to monitor that throughout this year to see how that impacts our revenues before we make any kind of recommendation on increasing grant territory, and want to make sure how that all works out. So
in this fiscal year, we won't see the full impact of that because we did collect exam fees for the October exams this year. So really, it'll be next fiscal year when we'll see the full impact of that transition, I think. Yeah.
John, may I ask everyone to please speak into the microphone, because I'll get a half a sentence sometimes. And Robert, would you mind repeating about the grant money and the financial committee action?
actually, I just said Susan Ballard's a wonderful person, but I'll go ahead and say that again. So you made me say it again. What we're looking at on the grants, because we don't know what the impact of revenue is going to be on the computerized test for the fundamentals of engineering. We are going to take we're going to monitor that over the next year and see what effect it has on our revenues and what we think it looks like going forward from potential registration, decreasing some registration in the upcoming years before we make a good decision on increasing or asking for an increase in our grant allocation. We just don't want to do anything right now because the water's kind of muddy.
Right. And we don't want to knee-jerk have a reaction on it, but I do think we need to have a plan in place should we need to do something to increase interest in taking the exam. So.
What are the third-party professional services? What do they tend to be? I see what they were for this period, but...
Yeah, it's a variety of things. traditionally, our exam expenditures have been under that category, although that's soon going to be going away. That's usually the biggest chunk of it. Expenses primarily paid to NCEES for the exams. Also, it covers transcript evaluation, online credit card fees go in that category because it does cost us some money to offer that service to registrants to renew online. We're hoping that fee will eventually go away, but for right now, we still have to pay some fees for that. It covers document destruction services. All council dues fall under that category as well, like dues that we pay to NCARB, NCEES, CIDQ, and CLARB, and the Southern Conference of NCARB. They all go under that category as well. And I think that covers the bulk of it. I may be omitting a few items, but that's the majority of it. And I think those expenditures are going to be going way down in the future because we're not paying those exam fees anymore. The registrants are paying their fees directly to the national councils instead of paying them to us and then us paying them out to a third party. Yep. That's all I have for my director's report.
Okay, I do want to make one comment. I really like the way that the assistant commissioner is engaged and the commissioner is engaged with the board. It's a nice breath of fresh air. So, meeting him the other day when I was here, he's a very outgoing, friendly guy, and I guess everybody saw how he was today. So I think we're in good hands. So, all right, let's move on to the engineering committee report. Philip, I believe you're going to make that today.
The chairman, Mr. Chairman, Howe is not here, so I'm reporting on behalf. Real quickly, we talk about commissioning work, that we believe that it should be an engineer to do the commissioning work. Right? You'll correct me if I'm wrong.
Correct, that, that an engineer, if it's commissioning of an engineered
Right.
system, that it would be under the responsible charge of a registered engineer.
Yeah, thank you.
Yes.
Is that just if it involves design work? What if it's just somebody checking balancing or something like that?
Right. If it's just somebody checking balancing, it would be our board's view, or what we talked about yesterday. That's not engineering. We're talking about getting more in depth,
design,
more in depth commissioning, not design, because commissioning agents are different than designers. But when they commission a engineered system, that is where they get into more than just checking balancing and that sort of thing.
When I was reading that paper about it, I picked up on a little phrase about building envelope, and that raised the flag for me that when you say building envelope, that's normally what an architect is involved in, versus say an HVAC system, electrical system, sprinkler system, so on. So that area is one that I would be concerned with, because we're specific in saying that. In one paragraph, I should have highlighted it, but I'll find it and send it to the other board members so they can see what I'm talking about. So I would
John,
be.
so John can forward to all of us. Yeah.
Jerry, a quick response to that, and Ricky, I may be speaking a little out of turn on what I'm saying, but I think from a design standpoint on the building envelope, we agree that's an but I think there's also some testing that goes along with that to check the vacuum and the
balances, yeah.
porosity of the seal and all that on this building envelope. And I think more of that is what that comment was directed to, not the design of it, but in commissioning, they may go in and actually do a vacuum on the building, from what I understand, to see if it's how airtight it is. So that's why I get for reading these home builder magazines. But anyway,
Just a question to Jerry and to Frank. Who prepares your energy models? Do you do that in-house or do you hire an engineer?
It's easy for me. We've got a mechanical engineer in the house.
So it's an engineer performing the energy
Engineering
model to make sure that,
Yes.
you know, your code calculations are correct, because,
Yeah.
I mean, we don't do it as an architect.
And I would engage an engineer to do it myself, because that's an area he's got the expertise, not me.
I'm just, yeah, Rick.
And the other comment I have is, I mean, Jerry's point is, I think, well taken, that there's really no limit on what you could commission. You could commission the roofing to make sure that that's installed according to the roofing spec, or any part of a building. So it's just, I think traditionally it's been the HVAC systems and maybe a little bit of the electrical systems, but there actually is no limit. So the way the other states have, the way have addressed it so far is either they haven't thought about it, they haven't decided, or what they say about it is kind of general in nature. And I think the statement that we would endorse is kind of general in nature. But you're right that, I mean, the point's well taken that if commissioning roofs becomes a big deal, or envelopes, that may well be an architect commissioning a wall installation.
Now, part back to your question, you know, state projects, you've got the Tennessee Energy Conservation Code
Yeah.
to deal with. And part of that is filling out a matrix or a computerized fill in the blanks thing, I guess you'd say, for the design of the how you're meeting that design. And part of that is architectural questions.
Yeah.
Part of it's HVAC, part of it's electrical. And so, you know, but I think I agree with everybody here. If it's a technical commissioning of a building to see if the HVAC is operating as designed, or the electrical system operating as designed, then that means to be done by a design professional.
Take that long, but next thing we had was we're talking about, there was a letter presented to us. Somebody was doing some kind of forensic investigation. The question to the engineer board was, should this person be registered in the state that he's doing investigation where the problem happened, or should he be registered in his home state while he's doing the work? It was very clear to us as the engineering committee that if the forensic happened in that state, if it's in the state of Tennessee, then he has to be registered in the state of Tennessee to perform that work, because he's offering engineering services. So it's in line with it. So John is going to respond back to the letter for us. We'll talk a bit about continuing education. We probably won't do about the other thing. So we also discussed a little bit, which is going to come up in a minute, is talk about qualification-based selection process. I'm going to leave that alone. Our annual meeting for the NCWES will be August the 20th to 23rd. Then we have the Southern Zone meeting coming up on April 24th to 26th. I do know for sure that Stephen King is going to the Southern Zone meeting, because Mr. Howard Bartrop, our chairman, said he has to go. So that's all I have for an engineering committee.
Mr. Lim, one thing that we did discuss is having a meeting, an open forum next meeting with input on taking the professional engineering exam after passing the fundamentals of engineering exam, but where you would still have to have the 4 years of experience, but you would just be allowed to take it at some point between obtaining the years of experience. So we're going to have a forum on that next engineering committee meeting. Is that correct? Okay.
Thank you. Omitted that. That's all I have, Mr. Chairman.
Thank you, Philip. Finance, we've already, or do we have more?
No, I put everything out.
Okay, we're covered on that. Landscape Architect Committee report, Bill?
Bill's not here.
Oh, I guess we don't have one.
Robert can report on that.
Yes.
Okay, Robert, you report.
There's a fundamental question in landscape architecture. What's the difference between a bush and a shrub?
I don't think you ought to go there.
Yes.
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 But Bill's the one that gave me the joke, so but I just have to wait
Till he tells you the answer.
until he tells me the answer.
Well, thank you for that committee report. We have some unfinished business. I think, is all this under Susan's?
No.
No. Oh, Susan's just on the last one.
Right.
Okay, it goes back to you, John. I'm sorry. I was looking.
Action items, yes.
Yeah.
Page 36 on your iPads there. Action items from the October meeting. Under my name, they have all been completed or are in the process of being completed. The one about the letter about interior architecture, that's on the agenda for this meeting, so that one has not been completed yet, but it's underway. As far as the letter of undertaking in respect of the mutual recognition agreement between NCARB and CALA, the Canadian group, architecture group up in Canada, did send a letter to NCARB. I haven't gotten a response at this point, but we've since been notified that that agreement has been ratified by the required number of jurisdictions, so it is in effect at this point. We're just not a signatory to it. So I expect that in the near future, we probably will hear something from NCARB about that, some response from them. And let's see, Mr. Thompson still has not written the newsletter article, but we're still discussing that issue.
That's correct, and I'm learning more and more every day.
Yes.
Because we do have a good response from Mississippi. I believe it was Mississippi, wasn't it? There was an article in their newsletter that you forwarded to me.
Oh, that was South Carolina.
South Carolina.
Yeah,
Oh,
South
okay,
Carolina.
well,
Yeah.
But that, I think it's going to take a little more thought to write that article.
But we will need to publish our next newsletter fairly soon, so we may have to just draft what we've got at this point for an article.
When is that? Is it next quarter?
Right. It'll actually be the fall winter 2013 edition, although it may go out early next year potentially, but that'll.
We're having holidays right now, don't you?
Yeah, exactly.
Okay.
Yes, yeah. We may have to draft sort of a brief article about QBS and then promise more details in the near future. Yeah, it's probably what we'll have to do.
Okay, thank you.
And let's see, mega issues. Of course, we discussed that somewhat. And rule changes are underway, as well as QBS guidance. Finance Committee had their meeting today and discussed those issues on the action items. And the Engineer Committee did discuss commissioning, allowing applicants to sit for the PE exam before completing experience, and forensic engineering. So they're all either completed or underway.
Okay. Then I guess that would take us to the letter. Use the term of interior architecture. And Susan, I believe you've addressed this.
Yes. After our meeting at the CIDQ, I think we are going to feel comfortable with issuing the letter as is. I have been talking with people across the state, and the programs, architectural and design programs, still strong about them being able to do, but we want to issue this letter, to state that it's not a recognized profession. And I don't know that we can stop it, but we'll have our, position noted as such. And those people who are in education, some are for it, some are against it, but I think we need to go ahead and send it out so that they understand where we are.
Okay. A comment on that. There are universities that do this and call it interior architecture, but you have to go through architecture school while doing your interior education as well. So therefore, they are architects. And Auburn's one. I just happen to know that. So
Okay.
there are others, but it puts the responsibility on the educators, the schools, and the students to get an architecture degree and not an interior design degree. So I think this letter is very well written, and we need to make a point. There's no exam. So if you're misleading your students, that's just
exactly.
They're over promoting something they can't do.
Right. And that was another point that was brought up in some of our meetings in Vegas, was that there are individuals who think they're graduating and being able to, practice something that doesn't exist, and it doesn't exist in Tennessee. And I think we need to make sure that we've covered our bases as a board. So,
Thank you. with that said, is there any additional new business to discuss?
Skipped a few items under
I did?
unfinished business.
Where? Oh, I'm sorry, you're right. I was just getting ahead of myself. We do have the report on the NCIDQ annual meeting. Susan, my apologies.
That's all right. John wrote out a little synopsis of our meetings. It were 2 days, and we had a very nice location, which was across the street from a Frank Gehry architectural designed building, which is extremely interesting. And the exam has gone through its new changes, and they're trying to educate everyone as to the new steps to get registered and what the process is going to involve. We had, I would say, 40 people there, and we have a new director, so we have staff changes that have occurred, and so I think she's very enthusiastic about moving forward, and she's already made changes that have saved the organization money, and I think her leadership will be a fresh beginning for the new exam as well. And if there's anything John wants to add.
No, you covered it.
Okay. He didn't tell me where he went Saturday night, though, after our meeting in Vegas.
Yeah.
So, next year we're going to Albuquerque, New Mexico. So.
Well, I'm starting a project in Albuquerque next week, so I can't wait to get out there.
Check it out
I've been
for
there
us.
one time. So.
Yeah, I can't wait to get there. Okay, now, have I missed anything on here?
Proposed rule changes.
Oh.
That's a big.
Oh, okay, we jumped ahead on the qualification-based selection stuff. I got you. Proposed rule changes. My apologies, John.
Page 38. And these are quite a bit more extensive than what we discussed in October, because we've had to add some things. The first bullet point there under architects, engineers, and landscape architects, this is the language that y'all drafted at the October meeting to amend Rule 012002.02, Section 2 regarding proper conduct of practice. This was a suggestion by Joe Carson, who is an engineer in the state, that's be broadened somewhat to state that a registrant, if a registrant becomes aware of a decision taken which violates federal, state, or local laws, regulations, and codes, then he has to report the decision to the authority having jurisdiction. So that's the main change to that particular rule. That won't be a surprise because y'all approved that in October. Also amending Rule 012002.07 misconduct by adding a new paragraph stating that the registrant may not utilize the seal of another registrant without the other registrant's knowledge or consent, which sounds a little odd, but that's in response to a recent complaint we had where someone who was registered as an engineer used another registered engineer's seal without that registrant's knowledge or consent, which seems kind of odd if you got your own seal that you would use somebody else's seal, but that did occur. And we don't have a rule that specifically addresses that situation. So I think it would probably fit best under the misconduct rule, perhaps, rather than the seals rule, which is where you might normally think that would be. But that's open to discussion. There was a lot of discussion about that proposal in October. Some thought it was a good idea, others not. So, yes.
Just a comment, a wordsmithing comment, John, on the Item 2, proper conduct of practice to read as follows. I meant to say this the last time, but the last underlined comment, the safety, health, and welfare, the way it's referenced everywhere else is HSW. So just, it doesn't, if that's.
I think we actually adopted that wording
did?
from the first paragraph to make it consistent.
Okay.
In the first paragraph, it reads that way, and then in the second paragraph, it says public health or safety. So we're trying to make it consistent within the rule itself from one paragraph to the next. So that's why it's worded that way.
Change our continuing education credits to S. No.
We can move on unless there's any discussion about either of those. Under all professions, this is a new one that we didn't discuss in October. You may recall earlier this year when I did a legislative update, I made you aware of a recent law change, Public Chapter 122, that requires licensing boards to develop a process for expedited issuance of licenses to veterans and their spouses. Also requires us to waive renewal requirements for those on active duty and to develop procedures to accept military education, training, or experience if it's substantially equivalent to state standards. So the division has developed some model language that they would like regulatory boards to use in implementing this statute that passed earlier this year. And following there is some wording based on this model language. The engineers discussed it yesterday afternoon, and they were not very comfortable with the process of issuing a temporary permit because that's a significant departure from our current practice. We've never issued temporary licenses or permits. Some states do, but we never have. We don't really have a procedure for that. It would be an involved process trying to implement that because we would have to develop a new application form for this, and the renewal requirements would be complicated. So I think the engineers were, I can let the engineers speak to that if they'd like to, what your position was on that.
Go.
Maybe your position wasn't as strong as I thought it was.
No, we were.
I think the objection to the temporary permit was that there's a health, safety, welfare issue here. If you didn't know that someone was had the qualifications, we didn't feel like it was in the public's best interest to let them go out and design things without that process happening.
I believe the feeling of the committee was that if you're going to go to extend the issue temporary permit, what happened if this person really not qualified after you find out about it? What are you going to do with all this building or all this design he's done for the public? So rather than entire issue temporary permit, I think we should expedite our process. And that process can be expedited pretty easily anyway.
I mean, I think our feeling is that we can turn around somebody's application in a matter of days, obviously less than a week to 2 weeks probably. So by the time we issue a temporary permit and do all that, we would have the real thing done. So there's no advantage to having a temporary permit.
We'll still have to put some language in the rule, right, Rob, about expedited processing or issuance of a license. So I don't know that we can just put language in the rule that says we'll just process it speedily.
I mean, I think that language, John, I'm sorry for interrupting, but I think that language just needs to say that if we receive those applications, they will be placed at the front of the line to be done within 2 week time period or something. I mean, I think that's expedited.
I'm gonna look at some of our other boards, try to get some. The other ones we're using that we can redact part of it before we have to try to write it ourselves. Because every board, all 23 boards in this department have to do this. And if somebody else is going to do something that we can use effectively, I'd rather just use that.
Can we add the word completed application? Just because they give us one doesn't mean it's one we can process.
I'm sorry, I didn't understand the question.
Okay. I was just making a comment that on the application, I mean, they can turn in one that may not be completed, and we can't turn it around in 2 weeks. But I think we need to add the word or adjective completed application so that if it doesn't meet all the requirements for the information we need, we can't expedite it, okay?
Right, yeah, that makes sense. Yeah.
It qualifies it.
Frank? Yeah, I was gonna ask, is there, what's the history behind why there's the temporary permit in here in the first place? Any?
This was developed, I think, by the division's legal staff, right, Rob?
Yeah, it was pretty broadly written, and some programs do have permit programs. We're not one of them. I don't think we're going to trouble ourselves too much about it. We're just going to have to figure out some language that works for us. It's just that we were commanded to do this by the legislature, and the comptroller's office expects us to do it.
Right.
And
I guess the other part of that I was gonna say is, you know, if we have to put this in here, let's say, there's nothing that says we have to issue a temporary permit for anybody that walks in and says they want one.
And the law doesn't even mention temporary permits. That was just, I think that was felt that it would be appropriate for most programs, but not necessarily ours.
that would be one of the only mechanisms, or one of the mechanisms some boards have to speed things up, to issue a temporary permit. Or should we? Because I just don't think our professions are suited for temporary permit status. If you're a security guard, it might be one thing, but not an engineer or an architect.
Mr. Chairman.
Yes.
You know, Rob, the point is well taken. The point I'm trying to make is that even if you issue a temporary permit, we still have to do due diligence to go through his or her paperwork. And by the time we go through it, if it's qualified, it's qualified. It's not. Now, I can see that something we might say we need additional information, perhaps. But by and large, the staff pretty much can screen it right then. Because issuing a temporary permit is the indications that we don't have to look at all the detailed information, just give it to them one blindly. That's just give me the feeling that way, but anyway, just and it just doesn't do us any good anyway.
Well, this applies to all the state government, I think, the statute, and I guarantee you the medical doctors board is not going to issue a temporary permit. So I think we got a pretty strong argument for our professions too. I don't think that was contemplated that thou shalt have temporary permits, because it's just not right for us.
That may be a good model for us to follow, whatever the medical boards adopt, that we might be able to utilize some of their language. I did check, I think a week or two ago, to see if any other boards had already adopted some language like this, and they had not. Even the medical boards, they had not.
As usual, we're out ahead.
Yeah. We're at the forefront of this issue, as always.
Maybe one more specific thing, if you feel like language like we'll do it as fast as we can isn't specific enough. What if you say that the paperwork won't wait on our regular meetings? Like, we review applications at our engineer committee meetings every 2 months. We would say, you know, we would arrange a phone call when we receive it instead of waiting for the regular meeting. That's something specific that you could offer.
Wait, one of you, just to handle those when they come in.
That's an idea.
Yeah, that's
Just
true.
to speak for
Maybe you
all-
could authorize one board member to review, the chair, say, could appoint one board member to review and approve those applications, maybe subject to ratification by the full board or something.
Just report.
Yeah.
I like that better.
Stephen?
Yesterday in our committee meeting, we talked about giving staff the ability to approve those in certain situations. Did I dream that?
Yeah. I mean, in fact, one of the things I was want to brought up, see, right now under the model law, John pretty much kind of approve it, and then the engineer members just sign off on it. But that has to be formally adopted in our rule.
Yeah, and The law that deals with approval of applications does not give the staff authority to actually issue a license. So we'd have to do it like the model law, where I would review them and then y'all would.
We still had to sign off.
Yeah, I mean, we could do it that way. The only thing that concerns me is there might be some cases where I may not be comfortable reviewing it. They may not be model law engineers or blue cover architects, or they may not meet those stringent requirements, in which case I would want y'all to review them anyways.
You can defer it to us.
Yeah.
I think that's probably, it's a two-part answer then. I think it's in those cases where a application from a veteran falls within the limits of the model law, we will give staff the authority to approve those subject to our ratification. But however, if it falls outside the model law, we will electronically vote or electronically vet the application among the board members in order to get a response that will be better than a regular scheduled board meeting or regular meeting of the committee. And I think it's probably a two-part deal. Does that sound right?
The other part of this is, of course, the experience, training, and so forth. That has to be substantially equivalent. So I don't have any heartburn over that particular section.
That's in the model law.
That's actually in the law itself, right? That we have to accept military education, training, or experience if it's substantially equivalent to state standards. So that substantially equivalent part is very important there. It would have to meet our current requirements. So I don't think that's problematic. And here the proposed rule just follows the language in the law. There's nothing added to that. The last section, section 3, deals with renewals, and where you would basically waive late fees and other penalties and allow them to renew, I think, up to 6 months following their release from active duty. And of course, waiving the continuing education requirements after they submit documentation to the board for the exam. I think that language we probably can't play with too much, because that's largely just taken straight from the law. And it's really not much different from what we already allow as far as waiving continuing education for those on active duty. We already have a rule that allows that. The main difference is we've never waived late penalties or extended the renewal period for those on active duty. So this allows that. All right. Any more comments on that? And also, I've identified the rules that would need to be amended to delete gender-specific language where it uses the masculine in the generic sense. So that, as you can see, there's quite a few rules. I don't think I missed any, but it's always possible. So feel free to review those and see if I've left any out. But I think those are all the rules that would need to be amended to delete any masculine language. And finally, amending rules 0120.02.062 for architects, engineers, landscape architects, and 0120.04.10.11 for interior designers regarding misrepresenting one's qualifications. This was also discussed in October. This is largely taken from Mississippi's rules for architects. Yeah. It's been modified somewhat, adapted for our use. And I thought that probably the italicized text in this proposed rule would be deleted from the rule pertaining to interior designers, because it has to do with sealed documents and projects that remain unconstructed being listed as unbuilt or some similar designation. I didn't know if those would be appropriate for interior design since they don't have a seal and we don't regulate the practice. Did you have an opinion on that, Susan?
Well, I think we need to put a statement in that this project was not built, just in case the same thing can happen to the interior designer that just happened in the Arizona, Hawks case. So,
Okay. So leave paragraph E in there for interior designers then?
yes.
Okay. And one final rule change, which is not on your list here, because I just found out about it this week, is amending our qualifications-based selection rule to refer to TCA 124107 rather than 124106, since that law has been amended since the rule was adopted. So we've actually got some significant rule changes. One of which, well, two of which, I guess, the QBS and the legislation, the rule change for veterans and their spouses, those would be considered, I guess, urgent changes. So we'll definitely have to do a rulemaking this year. That was one question that we had in October, was whether we had enough to justify a rulemaking hearing, and we definitely do. So that may be scheduled for August potentially, maybe earlier. Probably not earlier. We'll see.
A question on the rulemaking too, and I know we discussed this yesterday, but for my memory more than anything, we have some rules that we need to modify because of the FE being computerized, and will they make it in this cut?
They've already been adopted.
I thought we were waiting on about the.
Yeah, they're still pending, but I mean the board's adopted them. That's what I meant to say. So right, they'll be hopefully take effect maybe by March.
Well, what didn't make the legislative package that we wanted to get?
Well, we had the change to delete the 8-hour reference for the exams. We deleted that, so I think we got all the earlier changes.
Did we have a discussion yesterday about
something was cut out of a bigger bill
that was made that we would go ahead and approve it anyway? What was that?
Was that
yeah, ours made it. Yeah, the 8 hours was removed.
So
is that survey?
I think you're thinking
Rob,
of surveyors.
Was it surveyors? Rob told us about that.
Yeah, I think Rob got confused. I think he was talking about surveyors.
Okay.
Our statute did get amended to delete 8 hours.
Okay.
Yeah, because the CBT is no longer in.
We had some. Okay.
Let me look here real quick and see when that statute was amended. Yeah, it was amended this year. It was Chapter 180. It took out the 8-hour requirement. Yeah. So we're good there as far as computer-based testing goes. Now, the rule changes are still pending right now, but yeah.
Okay. I know we had a long discussion yesterday about that not being in compliance, but that was just a confusion on the two different ones. Okay, just one minute.
So I think that's it on the rule changes. Now we'll have to draft a rulemaking hearing notice that y'all have to vote on. Of course, you'll have to do the economic impact and impact on local governments and all that good stuff with it as well. But that's for a later date after we get all the language finalized.
I think the last one we have is the QBS discussion. Yeah.
You saved the best for last.
Yeah. I don't know how I jumped ahead to the use of term interior architecture, but I guess it was something I was interested in.
Yeah. This isn't as interesting, but page 42 on your iPad, you have the FAQs that have been drafted, which are already out of date since it's referring to local government and local public works projects. the statute now applies to both state and local. So I guess now it would just refer to qualifications-based selection for public works projects or government projects, whatever wording you might prefer there. So a lot of these questions will have to be, amended somewhat, remove references to local jurisdictions and to the old statute, which is now TCA 124107A. I think that most of these were discussed in October. The first one, I don't think there was really any issue with that question. Certainly, that's just telling the jurisdictions that nothing has changed in the law. It's just the rule that's changed, that registrants can now be disciplined for violating the law. The projects, number 2, that the statute applies to, that wording has changed somewhat now as well based on the change to the statute. It applies to all contracts for, let me pull up the statute here, architectural, engineering, and construction services procured by any municipal corporation, county, state, development district, utility district, human resource agency, or other political subdivision created by statute. So it doesn't specifically mention, metropolitan governments and local towns, et cetera. But talked to Rob a little bit about this. I mean, since, the municipalities are political subdivisions created by statute, they're certainly still covered by this language, as well as the state has been added to it. So that language will have to be altered. Number 3, we added some language here. Does it encompass planning studies and other services that do not involve the preparation of sealed plans? This was partly the addition here was partly prompted by a complaint that was presented today about property condition assessments, that they would be included if they required the expertise of a design professional. I don't know if you would be comfortable with that wording or not, or whether that should be stricken.
Well, actually, that's different than what's read here. What's read here was a little vague to me. I think I even called and asked, because what it says is that would include property condition assessments that require so what you're saying is if they require by the requester, by whoever is requesting the services. Because otherwise it could be read to mean they require. We say,
yeah,
we are, in our judgment, they require. So I would encourage maybe some tweaking on the wording of that, and make sure we're clear on what we think.
If a jurisdiction requires that PCAs be prepared by a design professional, maybe, then they would be encompassed.
Or is it more the type of PCA that is being done as to whether it is considered? So there may be some types of PCA that don't require professional services, but there are some that do. So it's just depends on the scope of the PCA.
Because the ASTM standard, as a guidance, says it's suggested but not required. So if an entity went that step further and decided, but we're not taking a stand on whether we think.
So we're saying that if a PCA, gosh almighty, I just went off the thing here. Sorry. So we're saying if portions of the PCA require the expertise of a design professional, they would be included. Is that right? I mean, or is it portion? I mean, we're talking about not the whole PCA, but if any portion of it requires a design professional. I've never done one, so I don't know.
If the requesting entity says that it's required, is what I'm saying. And so that would kick it into they're being asked to provided. Does that make sense? Does that answer? I'm not sure if that answers your question. So yes, in a sense, if any portion of it.
So we could rephrase it. I'm sorry, Steve, go ahead.
Well, I don't think we ought to leave it in the hands of the requesting agency, because I work for a requesting agency, and some of the people that work for the requesting agency don't know what in the heck they're asking for. So it really boils down to, is it engineering architecture or landscape architecture? That's what we need to get at. That's my 2 cents.
Trying to read it again and again while you were looking for.
I was wrapping myself.
Yeah, I was going to. What's that say? What's that? One more time.
So you're saying leave it as is? Sounds like Steve is.
Well, Laura, you're saying you're referring to an ASTM standard, and it leaves it either or.
It does not require it. The guidance piece of the ASTM, at the end of ASTM, it gets guidance. It says it's suggested, but if the ASTM is what's used as the reference for what the scope is, then it doesn't require it.
Yes, sir.
Oh, sorry.
That's the way I read it.
Maybe to then address, Laura, what you were, the thought that you were conveying is, instead of saying that last sentence is underlined, maybe if it said something like, this would include maybe some types of property condition assessments that, due to the nature of the PCA, would require the expertise of a design professional. Would that says that there are some PCAs that don't, and there are some PCAs that would. Does that address what you were talking about?
It does, but it doesn't address what Steve was talking about, I don't think.
It doesn't, but I guess the initial thought was there. It seemed to be confusing in that we were saying that all PCAs require.
Exactly.
And that's not
what we're saying. And I don't think that we want to say that.
Correct. And so I'm thinking some language that says there are two, if it's of the type.
Exactly.
Okay, so what Ricky's recommending is that it read, this would include some types of property condition assessments that, due to the nature of the PCA, require the expertise of a design professional. Does that sound better to you? Okay.
I think that part of what we're saying, the question is, does encompass planning studies and other services do not? And I think we need to not be very specific on that, but I think we need to say any portion of any study, if any part of the study requires professional services, then yes, then you have to have a professional, and this will include such things as PCAs, planning studies, et cetera, et cetera, et cetera. So I mean, that's kind of what we're saying. If any part of a study requires any professional expertise, information, preparation, then the entire part of that would require that. Because you may be doing a study on something, I don't know, how many.
You're right. It may not be a PCA.
Yeah, how many white cars are driving down the road, and that would be. I mean, it would be a study, but it's not a engineered study.
Read your wording again.
Yes. First of all, does TCA encompass studies and other services that do not involve the preparation of sealed plans? And we say, in the event that any study, such as planning studies, PCAs, or others, or other similar documents, require some professional services in that study, then it will meet this statute, the restrictions of this statute. That sound right? Play it back here in a couple hours. It'll sound right.
We'll have to listen to it on the recording.
I think that's what we're trying to get at, is that any study, not just, because there can be 100 different types, as long as they've got some professional service element to it, will have to meet the intent of this statute.
Forward, please.
No way.
It's
Number 4 is about public school systems and building authorities. That would not have to change much from what was discussed in October. Same for number 5. That's a new question there. Actually, number 4 was actually suggested to be added in October. Number 5 is another one that's been added in response to a question that we recently received about charter schools, if they are included in the statute. And in fact, they are not, because they are private nonprofit organizations. So they would not be covered by the TCA statute that governs QBS. Number 6, that's the controversial one about whether the statute applies to landscape architectural services. We probably still need to do some more research on that, but I think Rob still sticks by his interpretation that it does. Right, Rob? Yeah, he still sticks by that. But it may be something we might not want to publicize just yet until we do a little more research on it. Number 7, that's a new question that may be controversial. Is it permissible for a registrant to provide a description of intended compensation, that is, whether you charge a fixed fee, percentage, etc., in response to a RFQ/RFP for a government project, public works project? And the answer is yes, provided that a specific monetary amount is not included in the response.
Would this address the issue that we had in August, where it was a percentage of a stated construction amount? In other words, the fee, and I may be misremembering this, but the fee was not mentioned. I thought it was that it would be a percentage of a construction amount, and the construction amount was estimated to be X. Does that make sense?
I think what this says is you're quoting how you will charge, not what your fee is. If you quote 3%, then you're in violation of the previous rule.
So if you quote that percentage, even if it's not, I'm gonna do 3%, and that equals $20,000. The 3% on its own
violation.
Yeah.
But if you say I will charge you by the state's sliding scale, or a percentage basis, or a lump sum,
That's
or a
fine.
fixed fee, all you're doing is recognizing how you will charge, Ricky.
And I agree with that, and I think this language needs to be clarified, because I think it could be interpreted that it'd be okay to say 3%.
I disagree.
Maybe say specific monetary amount or percentage, maybe a specific percentage.
Right,
Yeah.
right.
Yeah, I was wondering about.
Yeah.
Yeah, that makes sense.
Or percentage. Okay. Okay. See, number 8, that's not changed really any since October, although, some portions will have to be amended a little bit. Is it permissible to submit hourly rates and an estimate of man hours required to complete a design project? And the answer is no.
A times B.
But we got to ask it because people ask that question. Number 9, the 9 and 10 are highlighted because there was some question about trying to work with local governments to give them some options and to assist them in accomplishing their goals. And that's what number 11 addresses. That's drafted by Mr. Campbell. Number 9, is it permissible to submit a price in a sealed envelope? That was discussed today. The answer being no. You can only state compensation to a prospective client in direct negotiation following selection. Some different opinions expressed earlier in the meeting about that. And 10 is about a pre-qualification process. that one jurisdiction attempted to use at one time. I think they later followed a different procedure, but we had our question about whether this procedure complied with the law, where they would pre-qualify firms, and then those pre-qualified proposers would submit fees for consideration and final selection. And I think at that time, the consensus was that would not be acceptable.
I would like to lump number 10 and 11. John, I'm sorry for not raising my placard. As part of the discussion that we have, hopefully with some of these purchase or advisory that we were going to try to have that forum, are we not going to have something maybe with CTAS, MTAP, something? Because there's a part of number 10 that is, in my mind, against what we're trying to do, and that is make sure that a agency is using somebody who has the qualification. And I think we're running in a little bit of a tight line here, that if they've already pre-qualified 4 or 5 firms, they've met the intent of the qualification part of selection. Can they then go then asking pricing of those firms, and it may be in violation of the Tennessee Code annotated straight up, and that may be the thing, but I think we need to, before we put that out for publication, we need to explain why that is, because if I'm sitting there, I think, well, I've already pre-qualified it, I've taken care of I've got good people. Why can't I get pricing from people that are pre-qualified? Because that's kind of the purpose behind qualification-based selection, is so you don't get somebody that's not qualified to take care of that. So, my recommendation is 10 and 11. Maybe we have that as questions to be answered in the future or something, so that we can get a more cohesive answer to those scenarios that are occurring out there.
Good. And that number 11, that's the language that Robert drafted. I think you read that earlier, didn't you? I believe, into the record. So when we were discussing some other issues about alternate methods for determining possible cost. So again, like you said, I think in April is what the engineer committee suggested, that maybe in April we could schedule a meeting with some officials from MTAS, CTAS, maybe the Municipal League, and other parties that might be submitted as having a dog in the fight, so to speak. Maybe we could discuss those questions with them. Number 12 is unchanged from October. Is it unethical to sit in on a proposal interview? Because we did have a question about that, and it was determined that although that conduct is unprofessional, it does not violate any specific rule. 13, this is a new one. Does Rule 0120.02.026 apply only to individual design professionals, or does it also apply to corporations, partnerships, and firms? I think previously we thought it applied only to individuals, but in fact, all of the rules of professional conduct apply to both individuals and firms that have filed firm disclosures with the state. So, and we had a complaint today on a firm, so it applies to both.
I just told her to party. We'll be back in time.
14 is about what disciplinary action may result. I don't think there would be any question about that. 15, that's one that was discussed at length in October. Is it permissible for governments to ask for a cost range for a project? And there were different answers proposed, and I think the final conclusion was just to strike that question and not answer it. Right?
I think that goes along with some of those responses that I had that we need to have. Yeah.
Right. And finally, 16, that's just trying to dismiss correct the misconception that they can't consider price at all when selecting a professional. It's not that they can't consider price, it just has to be after they select the most qualified, then they can negotiate compensation. That's it on the FAQs, and then you have the notice that was published earlier this year, which will also require some modification. Now the statute has been changed, so we'll probably need to reissue that at some point. in the near future, since 124107 is now the statute regarding QBS. So I guess my question to you now would be is which of these do you think perhaps we should go ahead and publish, maybe in the newsletter, the next newsletter, to try to guide registrants?
Mr. Chairman, it appears like there were a lot of questions about whether we can use, whether they can put code the project based on price and everything. I think that might be a good one to go ahead and clarify then. Because we had cases where the people in the seal envelope put the prices of the project. That kind of, we know it's a no-no, so that might be a good one to start off. But you're going to create some controversy, that's for sure. But I would maybe just publish 2 questions, be all. Don't do too many.
I would put all the FAQs that we have talked about and made the changes into a newsletter article. I mean, let's go ahead and get it out there.
Let people react to it. Yeah.
So that would I think would be all except 10 and 11.
10 and 11, yes.
And 11 and 15.
15, of course, was struck.
And then we modified.
Yeah, and number 3's been modified quite a bit. We'll have to kind of listen to our recording and try to wordsmith that one a little bit. And I'll definitely, send the revised language out to everybody before we would ever publish it and make sure that everybody's okay with the language. Ricky's a great wordsmith, so I'm sure that he'll
You
edit
spell
it.
check.
Yes.
Grammar check, spell check.
Oh,
My English
I'm
teacher.
sorry. Yes. Ricky's a great wordsmith. Also, as far as the title goes, I mean, it's not just local governments anymore, it's state and local. What title would you prefer for this? Because I found out that that's pretty important, what terms you use, because before we just referred to them as public works projects, and some local
We just say
jurisdictions.
governmented project?
Yeah, maybe government projects.
Yeah, governmental project.
Or, I don't know.
State and local, publicly funded.
I think governmental sounds federal.
It does.
Okay. State and local.
Publicly, would you?
Publicly funded.
State and local publicly funded.
Instead of public works.
Okay. Yeah, because public works confuses people because they think
Yes.
it's only public works department projects.
Right.
Yeah, I ran into that. I've never even thought of approaching it that way, but
John, do we need to make a statement about unincorporated communities?
about unincorporated communities?
Yes. Do
Okay.
they fall under this as well? Those of us from Knoxville know that Fountain City was unincorporated for a long time, but they were still a government.
Yeah,
Publicly funded part of that apply to them.
the funding's not really the issue. It's really it depends. It's really about whether they're state or local government or not. Not so much the funding per se. That's why I'm
Can't
not.
do business if you leave.
We got 5.
Oh, we got, yeah.
That's why I'm not sure.
Don't leave, Susan.
Remember about charter schools. I mean,
I
they're
think right
publicly
now- I think right now it
funded,
just should
but
be-
they're nonprofit entities.
Right.
We're stretching it too much. I think we should just call it state and local publicly funded project.
Well, because then that people might still get the idea that charter schools are included because they're publicly funded by local governments.
Why wouldn't they be included?
Because they're not a municipal corporation, county, state, development district, utility district, human resource agency, or other political subdivision created by statute. They're a nonprofit organization. Right?
They receive
That's why.
public funds.
They get you back into state and local government, which I guess at that point, if you say state and local government, you're not talking federal government.
Back to original. What's wrong with what your title right now? State and local government.
State and local government projects.
Most state and local government are usually some kind of public funds in it they use.
And otherwise, I'm afraid you might get the idea that it's all about funding. If any project that's funded by state and local is going to fall under this. Which,
Yeah, and if it receives 5%
Yeah.
public funds, does that fall into this category, which I don't think is our intent?
Those are municipal corporations, right? Like
Yeah.
NES, yeah, Memphis Light Gas and Water.
That's right.
Yeah. So they're covered by statute.
Projects under the authority of local government.
So now I got the opinion on charter schools from Rob. So Rob, are you now saying that your previous opinion was incorrect? Is that what I'm hearing?
It was a test. He passed.
Okay, he was testing me. Okay. All right. So y'all think maybe state and local government projects would be good?
Do we have to define it somewhere, maybe?
Well, the statutes will be stated or be quoted rather in the FAQs.
Some way you for
Like question 2, it's going to spell out.
Right.
This basically it'll just quote the statute.
This is just for your title.
Right.
You're
This is
trying to
just
get
the
the
title, which is very important because people.
I shouldn't say just the
People can be it's not just
The title.
It's the title because that kind of sets the tone for the whole document. You know.
About public projects.
Aren't they just state and local public works projects? I mean, that's what we're talking about.
Roads and water pipes.
Yeah, that's too narrow.
Public works projects are also schools and everything.
Yeah.
General public didn't think about it that way.
I think it's just roads and sewers and
If you live in Nashville, you see those big yellow Metro Public Works trucks drive by. That's what you think about. People like Hal.
See, Rick had to leave because this type of discussion just infuriates him.
He can't even think
but
straight anymore.
But it's important.
Actually, he had to go meet another appointment that he had.
Oh, okay. Sorry, Rick. I apologize on the record.
His beloved was calling him up, so.
He must be obeyed.
From us, or can the attorney come out with something?
How about if we just brainstorm and bring something back?
Okay.
We'll
brainstorm.
Instead of public works, what if you said public agency? Is that
Local public agencies? That might work, yeah. State and local public agency projects. It doesn't sound good, but hey, it works.
Broader.
Yeah, public agency, okay.
Or just don't say it at all.
Rob, I heard you say something
Just say
about
public projects.
doing something, then bring it back. But I also heard Robert say we need to get this out there. If we are finding people, we need to get this out there.
What's wrong with just say state and local governmental agency?
Look, we're just gonna have to be wordy. Just go along with what it is in 124107A. And it says, well, here,
What about projects as
it
defined?
says all contracts, municipal corporation, county, state, development district, utility district, human resource agency, or other political subdivision created by statute. And just put that in the daggum title and be done with it.
Just put.
I mean, it's wordy, but I mean, you might as well go ahead and put what it is in there, and let's not try to
How
get
about
cute with it.
public projects as defined by TCA?
Hey, there you go.
Well, whatever. That's what I just
Public
said.
projects
Whatever,
as
that's fine.
defined. I like that.
By TCA.
Hey, Rob just earned his salt for the day. About time you earned it. No,
Did you hear Laura's comment?
What?
First question.
Define
Deal with
it.
that and define it.
Right.
And make
Yeah,
that
I can move
number
that up. The number 2, move that up to
Yeah.
number 1 so that they can see
Yeah,
right
that's good.
there. Yeah.
Remember,
Yeah.
yeah.
You could draw a dash line with an arrow.
Yeah, that's right.
Like a flow chart.
For public projects. That's good. That's very good.
He's the
Rob. I'm
chairman,
proud
he's the
of you.
secretary. Mr. Chairman, I move we adjourn.
Mr. Wagster, you're out of order.
Well, I'll be sending the newsletter out. I'll be sending the newsletter out to you very soon. Then that's in this material to incorporate into the newsletter.
So to finalize, you'll be sending that out. We will ratify this from a computer vote among the members, and then you will get it in the newsletter on its next publication.
And we will accomplish this in a manner that does not violate the Open Meetings Act. Correct.
Okay, that's very good.
Yes. Just for the record.
Okay, that would be great.
We will privately deliberate about this.
Yes.
That being the completion of today's agenda, I want to thank everybody for being here and participating. I also want to wish everybody a happy Christmas, Merry New Year, and I said that backwards on purpose. And I want everyone to have a safe trip to your family and to your homes, and we'll see you again in February.
Chairman, we need a motion to adjourn, please.
I've just adjourned us.
Is it a roll?
I second it.
Don't you fingers.
That's right. Don't
Robert Rules.
You got that right, brother.